Good afternoon, ladies and gentlemen. This meeting will come to order. This is the regular meeting of the Land Use Transportation Committee. My name is Malia Cohen. I'm chair of this committee, and to my right is Supervisor Scott Wiener, who is the vice chair, and to my left is Supervisor Aaron Peskin. Our clerk is Mr. Victor Young, and I also want to take a moment and acknowledge and thank our friends from SF Gov TV who are broadcasting this meeting today. I want to recognize Mark Bunch and Jesse Larson for their talent. Sir, do we have any announcements today?
Yes, please silence all cell phones and electronic devices. Completed speaker cards and copies of any documents to be included as part of the file should be submitted to the clerk. Items acted upon today will appear on the July 19, 2016 Board of Supervisors meeting unless otherwise stated.
Thank you very much. Could you please call item 1?
Item number 1, ordinance amending the administrative code to create a fourth preference for people who live or work in San Francisco in addition to the existing preferences in allocating city affordable housing units, to affirm the Planning Department's determination under California Environmental Quality Act, and to make findings of consistency within the general plan.
Thank you very much. Now, Supervisor Wiener is the author of this item, and I believe he has a short presentation for us.
Yes, thank you very much, Madam Chair. I'll limit it to 45 minutes, if that's okay. Just joking. Colleagues, today before us is legislation or an amendment that I'm going to offer for existing legislation to provide a preference and help for victims of fires, people who are burned out of their apartments due to a fire, to give them priority in accessing affordable housing. We have seen way too many fires in San Francisco year after year. Particularly in the last few years, a terrible epidemic of fires in the Mission District, resulting in displacement, where people are burned out of their homes with no notice whatsoever. Just a terrible tragedy and traumatic event for anyone to have a fire that burns you out of your home, where you lose your possessions, do not have a place to live. Even for someone with resources, it's a horrible trauma. But to put on top of that the insane housing market we have in San Francisco and the inability of a good number of these fire victims to be able to afford housing in San Francisco, it adds one level of trauma on top of another level of trauma, and we need to help. A few weeks ago, you'll recall, we considered legislation to provide preference in the affordable housing lottery for people who live or work in San Francisco. This is legislation that I'm authoring to say that people who live or work in San Francisco get statutory preference in the affordable housing lottery. Long overdue. You'll recall, colleagues, that I asked to send it back to committee so that I could amend in a preference for victims of fire, people who are burned out of their units. As a result, here we are today, and I've distributed language with the amendment. We know there's a lot of work going on to try to address the fire epidemic that we have. A few years back, you'll recall, the board passed my legislation to create the Good Samaritan program that provides a mechanism for landlords to take in victims of whether it's fire or earthquake or other disaster-related displacement, and to provide low rents for either 1 or 2 years with a temporary tenancy. And that has been a successful program. Another good solution to help people is on our agenda today, the Fire Victims Assistance Fund, sponsored by President Breed and Supervisor Campos. But we also need a longer-term solution, and helping people who are eligible for affordable housing because they income qualify and who are burned out of their units for at least 6 months, and giving them preference in the affordable housing lottery makes a lot of sense. So the legislation will place these victims into the same affordable housing preference category as people who have been evicted under the Ellis Act or an owner move-in eviction. We place a sunset date on this preference of December 31st, 2020, and that will allow us, or our successors, as it may be, to take a look at where we are with fires. Is this still a problem? How has the program worked? And then the board can renew the legislation at that point in time. We also have a cleanup amendment for Category 2 residents, people who are displaced by owner move-in evictions. When the Ellis Act affordable housing preference was created, it had a requirement that the person had to have resided for 10 years continuously in the unit. That was amended out of the legislation so that you don't have to have lived there for 10 years. But through an oversight, it was left in for owner move-in evictions. And so we're making that cleanup amendment to make the Ellis Act and owner move-in provisions equivalent. So colleagues, after public comment, I will ask that we put this amended language in to support and help fire victims access affordable housing, and then we'll ask this be forwarded to the full board with recommendation. The Mayor's Office of Housing and Community Development is here today to answer any questions that may arise. Thank you very much.
Well, thank you very much, Supervisor Weiner. Would you like to go to public comment?
I think at this point we can go to public comment, yes.
All right, folks, public comment is open at this time. Just as a reminder, you'll have 2 minutes to speak. You'll hear a soft chime indicating that you'll have 30 seconds remaining on your 2-minute allotment. If you're interested in speaking on item number 1, please come up here to the front. I don't have any cards in front of me, but if there's anyone that'd like to speak on item 1, please come up. Okay, seeing none, then I'm going to close public comment. All right, public comment is closed. Thank you. Supervisor Weiner.
Okay, thank you very much. So, Madam Chair,
Wait, hold on a minute. Supervisor Peskin, is there something that you want to say?
I just had a question through the chair to the maker of the ordinance. I support the additional category of eligibility, but with regard to the fourth preference, how do you define and how do you monitor people who work in San Francisco?
Relating to the original version that this committee
Yes.
had already put out and we sent back, I'd like to ask MOHCD to come up. MOHCD has traditionally applied this preference administratively, although not always, and it's not required to do so. So perhaps Sophie Hayward from MOHCD could talk about how that happens.
Thank you. Sophie Hayward from the Mayor's Office of Housing. We accept a proof of employment within the city and county of San Francisco.
What's that look like?
Typically, it's a paycheck or a copy of a paycheck or a benefit statement or a letter from the employer.
Thank you.
All right, thank you. Supervisor Weiner?
Thank you. So, colleagues, I move that we adopt the amendments that I have distributed, and I do have a copy for the clerk as well.
All right. Is there any objection to that? All right, without objection, so moved.
Thank you. Now, Madam Chair, I move that we forward item 1 as amended with positive recommendation. This has to sit another week. My apologies. Now, because it was obviously a substantive amendment, I move that we continue item 1 1 week.
1 week, okay. Mr. Clerk, can you tell me what day of the week that is?
The 18th, I believe.
I believe that is Monday the 18th.
Monday the 18th, all right. All right, without objection, this motion passes. Thank you.
This matter will be continued as amended to the July 18th meeting of the Land Use and Transportation Committee meeting.
Yes, that is correct. Mr. Clerk? Mr. Clerk, could you call items 2 and 3 together?
Item number 2, resolution authorizing the San Francisco Municipal Transportation Agency on behalf of the City and County of San Francisco to execute a grant application, grant agreement, and related documents under the State California Affordable Housing and Sustainable Communities Program as a joint application with the Tenderloin Neighborhood Development Corporation for the project at 480 Eddy Street. Item number
Go ahead. Go.
Item number 3, resolution authorizing the San Francisco Municipal Transportation Agency on behalf of the City and County of San Francisco to execute a grant application, grant agreement, and related documents under the State of California's Affordable Housing and Sustainable Communities Program as a joint application with Mercy Housing for a project at 455 Fell Street.
All right, thank you. Pardon my interruption, Mr. Clerk. So, colleagues, I understand the Mayor's Office of Housing, that they have a number of amendments that they will need to make to to these two items, and that these amendments will require that both items be heard at a fiscal committee. So what I would like to do is, after public comment, entertain a motion to continue these items to the call of the chair, which will then give the Mayor's Office of Housing time to substitute this legislation and work with the President's office to reassign these items. So that is the plan. Is there a representative from the MOH that'd like to speak on this quickly?
Hi there, this is Sophie Hayward again from Mayor's Office of Housing and Community Development. And thank you, you're exactly correct. Because of language that we are required to add to the resolutions, this is changing into a slightly different form. So we'd like to substitute the legislation next week and then move to budget if possible from there. Thank you very much.
All right, great. Thank you very much. Let's go ahead and open up public comment on items 2 and 3. If anyone would like to come and speak, please come up to the podium. You'll have 2 minutes to do so.
Oh, my name is Elva Johnson, and I think affordable housing is what community means to me as schooling on this partly in fixing up houses, and also even as your item 2 grant. Is being in process. Already, I have a certified letter from Washington, D.C. to get in his office. And even though they have already said things already reported to, level the housing, build these to, be able to create and some other, properties to where they can have one idea of what building that proceedings that I have in mind. But for the grant, I'm not going to, go and, put our love of our systems and, with children, I'm going to put it with our considerations of building houses, of the ones that I have built already for affordable housing. And number 2 is one of the processes that do, go with San Francisco, want to be services.
Thank you, Ms. Johnson. All right, are there any other members of the public that'd like to speak at this time on items 2 and 3? Seeing none, public comment is closed. Thank you. Colleagues, can I have a motion to continue these items?
So moved.
Madam Chair, upon consultation with the council, I believe there's possibility that we should refer these to the Budget and Finance Committee.
Correct, but I'm thinking that we have to work with the Board of President's office to make that referral. I don't know if we can do it from committee.
Yeah, we can refer.
We can refer. All right. Well, let's send items 2 and 3 to the Budget Committee.
Item number 2 and 3 will be referred to the Budget and Finance Committee.
So moved.
All right. Without objection, this motion passes. Thank you. Thank you for your help, Mr. Clerk. Could you please call item 4?
Item number 4, ordinance amending the Administrative Code to establish a Human Services Fire Victims Assistance Fund.
Thank you. President Breed is the author of this item, and she's joined us today. President Breed, would you like to present?
Thank you. First, I want to start by thanking Supervisor Weiner for adding fire victims as a preference to our preference for affordable housing categories, mostly because we all know that, sadly, there have been challenges with fires throughout our city where we've displaced residents specifically, and it's been challenging because we've not been able to provide them with any real opportunities or really any real access to affordable housing. And part of why I introduced this particular fund is because what's great about San Francisco and is the residents who live here who, when someone goes through a tragedy of this nature, many other folks step up to the plate. They want to help, they want to support, and this Fire Assistance Fund is one way to do that. So thank you, colleagues. This legislation will create a dedicated city-wide fund to help San Franciscans who have fallen victim to a fire in their home. A residential fire strikes without notice. Unlike many other significant life-changing events, there's no advance planning for a fire. No one expects it to happen to them, and many times it's not even a fire in your own unit. The fire starts sometimes in other units or even in other buildings, but suddenly you have no place to live. Low and middle income earners are especially impacted. Not only do they lose their belongings, they often lose their homes. And given the skyrocketing rents in the city, fire victims are particularly vulnerable to being priced out of San Francisco altogether. This happens to dozens of people every year. And last December last year, there was a fairly large fire in District 5 that displaced several families. One of the families, middle-income earners, but by no means wealthy, were able to find another unit, but they went from a two-bedroom apartment where they had lived for years, where their son was born, to a one-bedroom unit where they created a bedroom for their son and a nook under the staircase. Their rent went from $1,800 to $4,000 per month, and they are struggling to pay the expenses for their child with a disability. Hardship and rent increases like this cause families to leave the city, whether by choice or by force of finances. In February, we had another sizable fire in District 5 on Fulton Street, which displaced 16 people. I worked with the North the Panhandle Neighborhood Association and the Alamo Square Neighborhood Association to organize a fundraiser for those victims of the Fulton Street fire. But I couldn't help wondering, where was the city in all this? And why can't San Francisco's government provide more help to people when they're losing everything? The Department of Human Services currently does have some funds in its budget that are used for limited-term housing subsidies for fire victims who earn below 35% of the area median income. But they aren't benefits for victims earning over that 35% of AMI, and neither the department nor the city has a dedicated permanent fund for assisting fire victims. In other words, if you make more than $25,000 a year, the city just can't help you if you're a victim of a fire. My legislation will change that. It will create a permanent category six-figure fund to help victims who earn up to 100% of the AMI. 100% of AMI may sound like a lot, but a librarian making $70,000 a year or a married couple who both work as cooks or a hotel maid are not rich. They are struggling to stay in the city just like everyone else, and when fire strikes, we should help. With this legislation, the Fire Assistance Fund will be able to receive private donations as well as appropriations from the board and the mayor. Funds will carry forward year to year, and the specific allocations will be made by the implementing department, the Human Services Agency. There have been several tragic fires in the Mission recently and numerous people who have been displaced. I know how hard Supervisor Campos has been working on this issue, and I want to thank him for co-sponsoring this legislation with me. I was proud to work with Supervisor Campos in this year's budget process to help secure $300,000 for San Francisco fire victims. It is a very important step forward in those times of need. And thank you also to our Deputy City Attorney Tom Owen, to my Chief of Staff Connor Johnston, and Ben Ames at the staff at HSA. I do have some minor amendments to offer today, which sorry I didn't pass out to my colleagues, but I'll pass them out shortly. We've revised the short title to make the name of the fund consistent. We cleaned up a code reference and clarified this fund is for rental assistance assistance, not blanket financial assistance. And we changed the maximum benefits fire victims can receive from a set dollar amount of $10,000 to a max time period of 2 years. This better reflects the wide variety of circumstances and victims. HSA helps from a single individual to a family of 7. So, colleagues, I ask for your support of those amendments, and to everyone who's been a victim of a fire in San Francisco, whose friends, family, or former neighbors are struggling to recover from those fires, I say to you, finally, with this legislation, we can help. We can do more to support you in your time of need, and with my legislation, we definitely will. Thank you.
Thank you, President Breed, for your opening remarks. Do you have any staff presentations? Supervisor? No? All right, let's go ahead and open it up to public comment. Is there any member of the public that'd like to speak on item 4? Please come up. Thank you. All right, seeing that there's no public comment is closed. Thank you. President Breed, do you have any closing remarks or no closing remarks?
Thank you again for taking the time to hear this item, and hopefully you'll pass out the amendments and pass it to the full board with positive recommendation.
Okay, so we've got some amendments that are on the floor.
I'll move those amendments.
All right. Supervisor Peskin has moved the amendments, and without objection, those amendments are approved unanimously.
And I would move to send the item as amended to the full board with recommendation.
Thank you. I just want to note that this item is agendized as a committee report, so...
As a committee report.
All right, thank you. Mr. Clerk, did you get that?
This item will be recommended as amended to the full board as a committee report.
That is correct, and without objection, that passes. Thank you. Thank you. All right, thank you, President Breed, for joining us. Mr. Clerk, could you call item number 5?
Item number 5, resolution authorizing the Department of the Environment to submit applications for all grants offered by the California Department of Resource Recycling and Recovery.
All right, thank you. Do we have staff from the Department of the Environment here to present on this item?
Seems like a pretty straightforward item.
I agree, but all right, seeing that there's no one here from the Department of Environment, we'll go ahead and get started. Let's go ahead and move to public comment. Item 5. Really? Okay. Public comment is closed.
Madam Chair, I would move this common sense item to the full board with recommendation.
All right, thank you. And without objection, it passes. All right. Mr. Clerk, you ready for item 6?
Item number 6, hearing on how San Francisco medical cannabis regulations are impacted by the newly adopted state medical marijuana regulations and safety act, and any policy changes San Francisco needs to make to ensure the continued existence of a well-regulated medical cannabis industry.
Thank you. Thank you. Supervisor Weiner is the author of this item. I'm excited. I've been looking forward to hearing this hearing for some time now. Supervisor Weiner, I assume you'll have a couple of enlightening and thoughtful remarks.
Yes.
All right.
Thank you very much, Madam Chair. Colleagues, today we are holding a hearing on an oversight hearing on the Medical Marijuana Regulation and Safety Act, or MMRSA, that was passed late last year by the state legislature, and what San Francisco's current activities are and what the future holds in terms of our local regulations, because San Francisco will be required within the next couple of years to adopt local regulations around various aspects of medical cannabis. San Francisco has long been a leader in having a strong and well-regulated medical cannabis community. But this new state law changes how the state regulates and oversees medical cannabis dispensaries. This will impact our own local regulations, and as noted, we are going to have to revamp how we regulate and oversee medical cannabis in the next several years. It's important for us to understand how the new law impacts what we're doing locally, what changes we're going to have to make, and also making sure that we are actually doing this in the context of 2016 medical cannabis. I think there's a perception at times that medical cannabis consists exclusively of MCDs, medical cannabis dispensaries, but this community is much, much broader than that, and there are many types of medical cannabis businesses and organizations, a lot of innovation happening, particularly around cultivation and manufacturing. I have recently had the pleasure of visiting some of these organizations engaging in cultivation and manufacturing, and it's hard because there is no official permit. We're again operating under this model that it's all about medical cannabis dispensaries without all of this other innovation and these other organizations and businesses. And we need to make sure that our regulations are keeping up with the reality of where medical cannabis is today. And so today we'll be hearing from the Department of Public Health, Planning Department, Department of Building Inspection on the impacts of the of MRSA, or the Medical Marijuana Regulation and Safety Act, on our local regulation. We'll also hear from representatives from the medical cannabis industry about the impacts that they're seeing and what the needs are here in San Francisco, including, for example, businesses that are frankly legal under state law, but for which we don't even have a local permit in existence. This is an important conversation, and San Francisco needs to continue to be a leader in medical cannabis. And if we don't adjust to this new regulatory framework, we're going to fall behind the rest of the state, and our local community will fall behind as well. Now, of course, colleagues, as you know, there is a ballot measure in November that, if the voters pass, will legalize adult use, non-medical use of cannabis. I authored legislation last year to create a task force to make recommendations to the Board of Supervisors and the mayor about how to best regulate and oversee this broader use of cannabis here in San Francisco if legalization occurs. That task force is meeting and is doing great work and working very hard. But today we are focused on medical cannabis, which is already legal and has been for a few decades. So, colleagues, I look forward to today's conversation. And if there are no initial questions or comments, I would invite up our city departments, I believe starting with the Department of Public Health, to talk to us about what's happening and what needs to happen.
Great, thank you very much. Are you ready?
So bear with me for 1 second. The PowerPoint on my drive was corrupt, and I'm just going through my email to find the most up-to-date. So I apologize for the delay, but I do have copies of the presentation if someone wants to take them and hand them out to the supervisors. And I should be able to find a updated copy in a minute. And again, I apologize for the delay. What? Okay, I don't mind doing that. Is that okay with everyone? I can also send it to. Do you want to try? Hold on. Do you want to see if you can send it to me? Sorry. Worst case scenario here. If you can send it to me right now, I can download it. I just had an older copy. Can you spell your last name? COMERFORD at sfdph.gov. Oops, it was sfdph.org. Sorry, but it should come. See if it comes through. Can you try sending it one more time? I'm gonna get started, and then I'm pretty much I can pull up the presentation. Hopefully, as we get into the slides that have some of the maps that are a little more important. But I want to start off by saying good afternoon, and thank you for your patience. My name is Cindy Comerford. I'm here with from the Office of Policy and Planning from the San Francisco Department of Public Health. I'm also here with Aaron Starr, who is the Manager of Legislative Affairs from the Planning Department, and Dan Lowry, who's the Deputy Director of Inspection Services from DBI. And today we're here to present on the Medical Marijuana Regulation and Safety Act. And this comprises of 3 separate California state bills and 3 proposed bills that entail different aspects of licensing and regulating commercial cannabis dispensaries, cultivation, manufacturing, distribution, transportation, sales, and testing. And I do want to differentiate this a little bit. Today we're specifically talking about medical cannabis. There is also a state ballot initiative about adult use, and that's not the focus of today's presentation. What I'm going to do is I'm going to start off by just giving an overview of the presentation today. Maybe, Aaron, maybe I can have you try to get the slides up and I'll just keep talking so we don't lose a lot of time here. Let's see if you can find that. So what I'm going to do today is I'm going to very briefly give a legislative history of medical cannabis in the state of California, also in San Francisco. And then I'm going to discuss what our current medical cannabis system looks like in San Francisco. Next, I'm going to give an overview of the current state laws that were passed last year, and then the proposed pending state laws that are moving through the California State Congress right now. After that, I'm going to turn it over to Planning and DBI to talk about their role in medical cannabis. And then I'm going to conclude the presentation talking more about the key decisions that the city needs to make. And we're happy to take any questions after the presentation. I'm also here with Douglas Obana, who is the Environmental Health Inspector from the Department of Public Health, and I'm also here with Bill Strong, the Manager of Legislative and Public Affairs for DBI, and another inspector from DBI, Liam McCarthy. So I'm going to start off just talking about the legislative history of medical cannabis. So in 1996, the state of California passed the Compassionate Use Act. And this was a ballot initiative which allowed for the use of medical cannabis in California. And it allowed patients with a recommendation from a doctor to use medical cannabis. It also allowed for the possession and cultivation of personal use. And this law has since been expanded to collectives and cooperatives for distribution, and is kind of the basis framework for the laws that we have now in San Francisco. And in 2005, San Francisco passed the Medical Cannabis Act, and this created Article 33 of the Health Code. And I'll talk about that on the next slide. And since 2005, there's been several amendments to this act. And we've had 3 additional bills that were passed by the state last year, and then 3 proposed bills and a governor's trailer bill that is kind of makes up what we're seeing for our legislative landscape right now. It's not coming up. Okay, I'm going to go and use these slides over here. I apologize for the technical difficulties. But to talk about our current system right now, we have 28 permitted medical cannabis dispensaries. And unfortunately, we're not going to be able to see both maps because it was kind of in a PowerPoint. But this first map kind of shows the permitted dispensaries within San Francisco. And the second map that we won't be able to see kind of shows the distribution throughout all the different San Francisco neighborhoods. And what you would say is most of the cannabis dispensaries are located in the eastern side of San Francisco. So the Department of Public Health issues the permits after a sign-off from the Department of Building Inspections, the Fire Department, the Planning Department, and also the Mayor's Office on Disability. Additionally, the Department of Public Health regulates and inspects the medical cannabis dispensaries. The law right now stipulates that all of the medical cannabis dispensaries be organized as a nonprofit, collective, or collaborative. We don't issue separate permits for cultivations, but as a function of the cooperative, the medical cannabis dispensaries may grow medical cannabis to be distributed to its patients. And again, patients need to get a recommendation from their doctor and then become a member of a cooperative or a collective. We don't actually track patients at the Department of Public Health, but we estimate there's probably about 10 to 20,000 medical cannabis patients within the city.
I have a question for you, Ms. Comerford. Thank you for your presentation, and don't worry about the technology. We will make do. The overhead projector, the image that you have up is telling. You said most of the, correct me if I'm wrong, most of the MCDs
Yes.
are on the east side of the city?
The density, the most of it's on the east side of the city. So you would probably, if we were able to see the map, which kind of showed the density, we'd see the largest density would be south of Market, which I think has about 9 medical cannabis dispensaries.
So my question is, before you go on, is
Sure.
for what reason is there a concentration?
I think it's based on 2 reasons, and I think planning can discuss this in more detail. One, it's the allowed zoning that we have. We have an existing green zone, and then also a lot of it has to deal with the neighborhood conditions and neighborhood input when these permits come up for discussion.
I see. I'll leave my questions for zoning, but I'm going to go back to the phrase that you put, neighborhood conditions. I'm curious to know what that means, but you please continue. I'll
Okay.
save them again for DBI
Okay.
and planning.
And I will, when we kind of switch, I'll try again to see if I can get the presentation up. So let's see if I can. Okay. So bear with me with these 2 next slides. They're very text heavy, but they're kind of going through the laws that just passed, the new laws. So as I kind of said, the state of California passed 3 new bills, which comprise of the Medical Marijuana Regulation Safety Act. And the acronym for this act, for better or worse, is MRSA. So I will refer to it throughout the presentation as that. And through the Department of Consumer Affairs, this act creates a new entity at the state level, which is now known as the Bureau of Medical Marijuana Regulation, also known as BMR. The new regulations create a dual state licensing system. So essentially, different types of cannabis operations would now need to get a license from both the city of San Francisco and also the state of California. This new regulation creates 17 new license types that range from retail dispensaries, which we now permit, to non-retail license types, which include manufacturing, cultivation, testing, transportation, and also non-retail distribution. The new law allows for some limited type of vertical integration between the new license types. The new law kind of phases out the cooperative and collective model, and now the medical cannabis dispensaries or businesses could operate for-profit businesses. The local authority in this new law is rather broad. It allows for the city to determine its land use, its permitting system, the types of licenses that we would like to issue. Besides the dispensary, the city could decide whether it wanted to allow cultivation or whether it wanted to allow manufacturing. On the right-hand side of the slide, it kind of shows all the different state agencies that are involved in the medical cannabis structure. And you can see at the top, the Department of Public Health is not, the state agency is not the main permitting authority, but the new regulatory entity, the Bureau of Medical Marijuana Regulation out of the Department of Consumer Affairs. Cultivation would be permitted by the California Food and Ag, manufacturing and testing would be by the California Department of Public Health, and I'm not going to go through the rest of the list, but there's 11 state agencies in all that are now tasked with the new regulations of medical cannabis. So right now, there's 3 proposed bills that are moving through the state Congress, and it looks like they're slated to pass. Originally, MRSA was scheduled to go into effect this past March. The new legislation would make all of these laws go into effect on January 2018. all of the state agencies need to issue their rules, regulations, and guidelines by January of 2017. So just to let everyone know, the state has not come up with any guidelines on the implementation of the past or proposed new bills. The new state laws include 3 new bills. One has to do with applicants implementing employee training on MRSA if they have more than 20 or more employees. The second bill has to do with taxation and tax amnesty. And the third bill is a set of amendments that kind of goes back and revises the first 3 bills. And there's 60 amendments in all, so I'm not going to go through them, but some of them include packaging standards can't exceed what the state puts in place. There's now some exemptions for quality control for cultivators. And there's also more specific requirements around seed security and details on nurseries. Lastly, what it does, it changes marijuana to cannabis throughout the whole legislation. Also on the right, there's a governor's trailer bill. This bill makes amendments to changing the name of the Bureau of Medical Marijuana to cannabis. It also creates a lot of clarity in the existing legislation around license types and what department is authorized to do what. And it changes some of the authorities from certain state agencies to other state agencies. So that's kind of an overview of the bill. I'm going to turn it over to planning right now to talk about zoning, and then DBI will talk about the building inspections, and I'll come back and just kind of summarize some of the key decision points that the city needs to make.
Thank you, Cindy. My name is Aaron Starr. I'm the Manager of Legislative Affairs for the Planning Department. In reviewing MRSA, the Planning Department identified 2 steps that should be considered in order to address the outstanding issues with our current NCD regulations and to bring the city's cannabis regulations into conformance with pending state laws. The first item is to review and consider adoption of the proposed recommendations outlined in the Planning Department's March 2014 report on MCDs. And the second is to look at amending existing MCDs, agriculture and manufacturing use definitions in the Planning Code to address new state licensing classifications. In July of 2013, Supervisor Avalos introduced an ordinance directing the Planning Commission to prepare and submit a report to the board that evaluates the Planning Code's MCD location regulations. The report was adopted by the Planning Commission on March 20th, 2014, and subsequently referred back to the Board of Supervisors. The report provided a summary of the medical cannabis laws in San Francisco, as well as state and federal laws. It summarized existing controls for MCDs and recommended changes to existing regulations. It also addressed specific questions posed by Supervisor Avalos' ordinance. Staff has already instituted some of the recommendations that did not require legislative changes, such as requiring pre-application meetings for MCDs and requiring that MCDs follow the Planning Code's transparency requirements. However, there were several recommendations that require legislative action. The first of which is to enhance the DR process by adding commission findings for MCD mandatory discretionary review applications. Right now, there are no findings for the Planning Commission to consider when deciding whether or not to deny an MCD DR application. Giving the Commission some direction as to when they should take discretionary review and deny an MCD would help provide more consistent application of the city's MCD regulations. It would also provide the community and applicants a clear understanding of what is expected of MCDs. The second recommendation is to expand the green zone. 3 ways to do this would be to 1, reduce the 1,000-foot buffer around schools to 600 feet, which is the state standard. 2, allow MCDs in more zoning districts. And 3, permit MCDs on the second floor in neighbor commercial districts where they are currently prohibited. The 1,000-foot buffer significantly limits the area in which MCDs can locate, so they tend to cluster in some neighborhoods. In addition, San Francisco is a dense urban environment, and a parcel located 1,000 feet from a school could be in a completely different neighborhood or separated by a major roadway. Finally, there are several zoning districts where MCDs are prohibited, where it may be appropriate to locate. MCDs are not currently allowed in South of Market districts, PDR districts, NC1 districts, and industrial districts. They are not allowed on the second floor neighbor commercial districts. Opening up more zoning districts to MCD would significantly expand the green zone and helping to address some of the clustering issues and provide more even distribution throughout the city. The next recommendation was to remove the 1,000-foot buffer around recreational facilities that primarily serve children and teenagers. This provision is difficult to implement, and like the 1,000-foot buffer around schools, it's overly restrictive. Most recreational facilities serve various populations, and their programming isn't consistent. However, the department recognizes that there may still be a need to restrict MCDs around sensitive uses. Therefore, the report also recommends that a finding be added to the MCD application consideration that if an MCD is located closer than 1,000 feet of a school or recreational facility, whether or not that MCD is also located along a major path of travel for that use. So instead of an outright prohibition, it's more of a nuanced approach to the restriction. Finally, the report recommends that if the green zone is expanded, some sort of buffer or anti-clustering provision should be added to the city's MCD regulations.
So what exactly are you thinking about, Mr. Starr? I mean, you're making these recommendations about, particularly I'm concerned about the clustering issue. I represent neighborhoods that are on the southeast part of San Francisco, and a lot of, although not most of the Green Cross area falls within, I think, Supervisor Avalos's district. There's spillage, if you will.
Yeah. So Supervisor Avalos, in his district in the Excelsior Outer Mission Street, has a buffering requirement that doesn't prohibit MCDs from being located closer than 500 feet, but requires a conditional use authorization. So one reason the Planning Department recommended that the conditional use option be used is because the green zone is so constrained. I had a map, but unfortunately I don't have one. Oh, there we go.
SFGov TV, the overhead. Okay.
So if you notice, the orange zone is the current green zone of the orange area, and then the yellow would be if you allowed it in all districts that allow some sort of commercial activity and shrunk the buffer around schools to 600 feet, which is the state requirement, rather than 1,000 feet.
I think one of the things that I'm not seeing on here, and it could be just the copy that I have, is I don't see very much yellow on the west side.
There is a lot of yellow, or there's not a lot of yellow on the west side, but most of the west side is residentially zoned. What the 1,000-foot buffer does, though, is it restricts a lot of parcels in those neighborhood commercial districts that would otherwise be able to have an MCD.
So how do you, as you know, the southeast neighborhoods are going from industrial. We're losing PDR space that are, and this loss is resulting into residential parts of, new residential parts of San Francisco. So how do we reconcile this? How do we ensure that there's some equity in terms of, one, access for folks that are on the west side of the city, and two, so we don't have an oversaturation of green resources
right.
on the east side?
So going back to the report's recommendation, I think some of that could be cleared up with clear sort of findings or guidelines that are in the MCD, so in the DR application of what the commission should consider. So is there an overconcentration in the neighborhood? What is an appropriate concentration? Another way to do that is the clustering issue, to prohibit MCDs from locating with more than 500 feet, say, of another one, because they do tend to cluster. So addressing it that way. Right now the commission doesn't have any sort of guidelines on whether or not they should take a discretionary review and deny a permit. So it's mainly based on neighborhood opposition or support and staff's recommendation.
So I know you're a staff person, and I know the Planning Commission has heard this item and probably will be hearing, I think, another proposal later on this month, if I'm not mistaken, for a proposal for an MCD in a neighborhood. And what you are finding is that you have a lot of neighbors that are in opposition to aspiring entrepreneurs to opening up new dispensaries in the neighborhood. How do we balance that? You could have either super informed neighbors or super uninformed neighbors. Either way, it doesn't seem like it's a very fair process, and for those that are entrepreneurial in spirit and looking to open up MCDs, to really almost, from my opinion, wage war against a neighborhood. So, for example, in Visitation Valley, there's been many MCDs that have been attempted to be open, and constituents have really organized quite well to prevent this from happening. From a planning perspective, I know you got recommendations, but maybe you're going to be presenting them in later on in the presentation. I don't know. My questions could be premature, and if they are, then my apologies. Then you can let me know, and we can address them later on in the presentation. But how do we begin to neutralize this so that the process is just definitely more fair and on an even keel for all the parties that are interested?
Sure. One of the biggest concerns that we learned through the report from March 2014 was clustering and the impact that it does have on neighborhoods. So one of the recommendations to deal with that is to expand the green zone and provide some sort of anti-clustering thing so they don't cluster in particular neighborhoods. But also, planners, when they look at the code, they look at what's in the code and how they're supposed to evaluate an application. If there's nothing in that application that gives them any direction on that, they will defer to probably approval unless, they can find a reason not to.
So the expansion of the green zone that you're just describing, does that include the west side, or are we just talking about
Yes, it does include the west side. The map probably isn't the most legible, but the orange is the existing and the yellow is the expanded. So in the west side, the only way to expand the green zone, because there are so few so few commercial districts, is to shrink that 1,000-foot buffer to 600 feet, or somewhere in the middle of that.
Thank you. We can continue.
Okay. So the second step the department identified would be to modify certain definitions of the planning code to address new state licenses classification. So going back to the state law and what's changing on that. The state creates several cultivation licenses. Our existing agriculture use definitions, urban agriculture, neighborhood agriculture, and greenhouse, are currently silent on growing cannabis. They should be amended to either explicitly prohibit or permit certain new license types. For instance, neighborhood agriculture is principally permitted in every zoning district in the city, including residential districts. This definition allows up to a half acre of cultivation as of right. We also currently have approximately 30 cultivation sites in the city, most of which are categorized as greenhouses or nurseries, and which are located in PDR and M districts. This is likely the most appropriate place for them. However, it would be prudent to acknowledge that in the planning code rather than leaving it up to interpretation. Second, the new state law removes the nonprofit requirement for MCDs. Right now, MCDs are considered an institutional use because of their nonprofit status. Should they still be once that they're allowed to be for-profit? Should we have two separate use definitions, one for medical and one for adult cannabis, which is on the ballot this November? And should we continue to regulate delivery-only businesses the same way we regulate brick-and-mortar MCDs? These are all questions that should be addressed. And finally, the city should look at the three of our existing manufacturing use definitions. There's light manufacturing and food, fiber, and beverage processing 1 and 2, to either explicitly permit or prohibit the manufacture of cannabis products. These three definitions appear to be the most logical use categories for this type of production that would occur for cannabis products. But there are several differences in the license types, and not all of them are appropriate for the use definitions that I identified. And that concludes my portion of the presentation, and I'll turn it over to Down Lowry and Bill Strawn from DBI, unless you have further questions. Thanks.
Good afternoon. For the Department of Building Inspection, Article 33, San Francisco Medical Cannabis Act. Referral to other departments. Upon receiving a completed medical cannabis dispensary permit application and permit application fee through DBI, the director shall immediately refer the permit application to City Planning Department, Department of Building Inspection, Mayor's Office of Disability, and Fire Department. Section 3307 of Article 33, issuance of medical cannabis dispensary permit. Applications with provisional permits shall secure a certificate of final completion and occupancy as defined in the San Francisco Building Code Section 307 and presented to the director, and the director shall issue the applicant a final permit. Operating requirements for medical cannabis dispensary. Medical cannabis dispensary shall be accessible as required under the California Building Code. Prior to submission of a building permit, the applicant shall submit its application to the Mayor's Office of Disability. And over here, you can see examples of the routing of some of the permitting that's already been approved through the building inspection process. It shows you where it went through city planning, went through building, went through mechanical. It gets routed to a PUC, DPW, development fee, Mayor's Office of Disability. So this shows all the routing that these different permits have already gone through and got obtained. The Colorado State Building Code use and occupancy of marijuana. Business functions as follows. For the dispensaries, they call it a mercantile. That's all we have here is a M occupancy for the mercantile. For smoking treatment rooms would be a B occupancy. For grow facilities would be an F1 factor, F1 occupancy. That's factory moderate hazard. Marijuana oil extraction operations would be an F1 occupancy. Marijuana infused product, kitchens, bakeries, F1 occupancy. Processing and packaging would be an H3 occupancy, be a combustible hazard. Findings, comments. The 2012 International Building Code lists hemp products and tobacco as examples of uses to be classified as F1 occupancies, which very closely matches the functions occurring in marijuana grow facilities, marijuana oil extraction operations, and marijuana infused product kitchens, bakeries. Similar to California, Colorado State also adopted the International Building Code as a model code. The Washington State Building Code. The Washington State Building Code Council has adopted new regulations categorizing marijuana processing facilities as F1 occupancies. That's factory, industrial group, moderate hazard occupancy. That's what the F1 symbolizes there. So the State Building Code Council took action on June 10, 2016 for the renewal of the emergency rules and to move forward with permanent rulemaking regarding cannabis issues. The State Building Code Council updated emergency rules that incorporates the changes to Chapter 1 permits and Chapter 38 marijuana processing extraction facilities on June 10, 2016. Similar to California, Washington State also adopted the IBC as a model. Thank you.
Okay, I have two concluding slides, but I am going to, since we have the PowerPoint working, just scroll back to the first map here. So this was the map of all the dispensaries within San Francisco. And going to the next map, this is the one that shows the distribution throughout the neighborhoods. So we can see there's 4 or 5 neighborhoods that have the majority of the medical cannabis dispensaries in it, and then a couple other ones that have 1 or 2. So the density between our neighborhoods kind of ranges from 9 to most of the gray area where they don't exist. So kind of just to summarize here, what the current law looks like and what the new state laws look like. Right now in San Francisco, we issue one type of permit. Our permit is only for retail distribution at medical cannabis dispensaries. The new state law now allows for 17 new types of licenses. This includes cultivation, manufacturing, testing, distribution, and transportation. Right now, the organizational model of the dispensaries is a nonprofit. The new laws will allow for a for-profit. The business ownership type that we require is either a collective or collaborative model. This will get phased out within the next year or two. The local jurisdiction still has a lot of the land use. Right now, our current law is 1,000 feet from schools. The new law just stipulates 600 feet from schools, but we could make it more stringent and keep with our 1,000 feet if we wanted to. Currently, right now, we have no taxation on medical cannabis, and the new law gives the city the opportunity to impose taxation on cultivation, production, and dispensing. And I believe the state law, there is a pending legislation about taxing cultivation at a state level. So here are the key decision points for the city to make.
And presumably that's subject to Prop 218 and requires a 2/3 vote or a simple majority if legislators are on the ballot?
You know what? I apologize. I don't know the answer to the taxation question. I do know it's just on cultivation, and I think it would be about $9.25 per ounce. But I don't know if it's subject to that proposition. I can figure out. I apologize. So the key decision points for San Francisco right now are whether we want to allow or prohibit cultivation, whether we want to allow or prohibit delivery. Within the state law, it stipulates that delivery must be connected to a cannabis dispensary, so we couldn't have any types of third-party Uber-like delivery businesses. Delivery would have to be strictly connected to the dispensary. We have an option to allow or prohibit manufacturing. Aaron talked at length about the zoning, whether we increase or decrease the existing green zone. We also want to really think about equity, as Malia mentioned. In Oakland, they recently passed an ordinance looking at equity. They had a really interesting way of looking at it. Basically, what they did is they passed an ordinance that states that cannabis law enforcement policies that have already disproportionately affected communities of colors and that people could have issues getting into this type of workforce. So to address this type of concern, they said that the 6 police beats that had been most disproportionately impacted by cannabis law enforcement would have an opportunity to get a permit, or if someone had been arrested in Oakland for a cannabis conviction. So what happens is 50% of the permits have to go to either people from these disadvantaged communities or people who have suffered from law enforcement impacts from cannabis. And so what would happen is when they issue permits, one would come from this equity clause, and then another could be issued to another type of ownership.
So are you suggesting this is something that we
Not
should adopt?
suggesting it. I'm just saying this is, we should
Just
look at
present this as background information.
Yeah, I'm just saying this is what Oakland has done. I don't know if it would work in San Francisco, but there are a lot of different local jurisdictions that are taking the equity issue very seriously as we kind of move this new legislation forward.
I'm sorry, real quick, Ms. Comerford, going back. So has San Francisco's has the task force, have they come up with their own set of recommendations to present to us to begin to address the equity issue?
So the task force that we currently have is for adult use. And so this is a little different. This is for medical cannabis. I don't think they have addressed the equity issue yet. Right now they've been talking about land use, but I do think they will have recommendations for the board by the end of the year.
And they haven't made any recommendations yet.
They haven't. But correct me if I'm wrong, the measure that's on the ballot in November is going to be addressing adult use.
Right.
So we should be forward thinking in the policies.
Right.
That's why the task force exists.
Thank you,
Yes,
Supervisor Wiener.
Yeah.
Yes, and the Department of Public Health is heading that task force, and I think equity is one of their main things that we will talk about. Also, taxation, how we tax medical cannabis will have a big impact on its output. And the last thing we...
Quick question.
Sure.
Let's go back to taxation. Is there an estimation on how much new revenue will be generated?
I don't have an estimation. I know right now when we looked at different systems, for example, the state of Washington had an adult use track and a medical cannabis track, and they ended up merging them because they had a tax structure that was very different on medical cannabis than it was on adult use. And now they just have a 37% tax on both.
Now, from a Department of Public Health perspective, you mentioned earlier in the presentation that you guys don't track medical cannabis use. Is this something you're going to be tracking moving forward?
So the state now will implement a tracking system, and it will be twofold. One of them will be tracking the actual seed to sale of the medical cannabis, and they also will have a patient tracking database. So that will be done at the state level.
And for the city and county of San Francisco, how many licenses new licenses will be created in order to address this growing industry?
So right now we have 28 licenses, and I think it's really going to depend on the zoning. Because I think, as Aaron said, there's not a lot of opportunity for new businesses to come in right now, just because of space issues. So I think we're going to have to look at if we want to expand the medical and adult use we're going to have to really think about the taxation and the zoning to allow for this new industry to expand.
All right, thank you.
And then just the last thing that we need to do is really, the state will give preferential treatments to new permits that the city determines has been in good standing. And so that's something for the city to look at to determine what is good standing. So just next steps, very briefly, we need to, as a city, I think we really need to participate in the state agencies that are currently developing the new laws and regulations. We need to develop a city process for working with our key stakeholders and informing the key decisions that I just talked about. And lastly, we'll need to develop local legislation to codify the state legislation and also the new local decisions that we make. Thank you.
Thanks. And also, I just want to jump in. I think a lot of times when we talk about medical cannabis locally, the issue that sort of dominates is the clustering issue, the green zone, red zone issue that I think it frustrates absolutely everyone. It frustrates, I know, our planning department and other departments. It frustrates people who want medical cannabis dispensary in their neighborhood but can't because the neighborhood is completely or almost completely off limits. And it frustrates the people who live in neighborhoods that are green zones because even though they may be very supportive of medical cannabis, they don't want a clustering of dispensaries. And I think it frustrates the medical cannabis community because there are only certain areas where they can go. And sometimes the system encourages clustering because of all the areas that are off limits. So, for example, in my district, in the Castrover Market area, the bulk of the neighborhood is completely off limits. There's like one area along Church Street near Market where there is a very small green zone, but most of the neighborhood is completely off limits. And we know that there are parts of the southern part of the city and southeast where it's the opposite. And so it's just a really challenging situation. And I will say that we have asked the task force in terms of planning for the possibility of adult use legalization to really try to make some good recommendations around how to address the clustering / green zone, red zone issue to have a much more equitable system, because right now the system is not working. I also think it's unfortunate that the clustering green zone, red zone issue so dominates the debate, because we know that the cannabis industry is so much more than simply dispensaries. And I think a lot of times when people hear cannabis, they immediately think just of the dispensaries, and of course they immediately think of just the worst case scenario and the sort of the sketchiest kind of dispensaries, instead of the bulk of the dispensaries that are run very professionally and don't create problems. But we know that this industry goes so far beyond dispensaries in terms of the cultivation and the manufacturing and the products that are not smoked. This is an industry that is just innovating and flourishing and creating so many kinds of products with businesses that may not have any interaction with the consumer whatsoever. So there won't be even people going in and out. But they simply need a place to operate. And so our laws are just way, way far behind in terms of recognizing the breadth and diversity of this industry and this community and the products they produce, and the need to have a modern and rational permitting system that takes into account the breadth of this industry and doesn't just try to pigeonhole everything into the MCD category. So I think that's really one of the challenges that we have, both in terms of implementing the state law locally, creating the needed permits and parameters, and also in the possibility of future adult use legalization and our local regulation. So I think it's important to keep all that in mind. So thank you for the presentation.
Thank you very much.
So the city presentation is done. Okay, thank you. And Madam Chair, if there are no additional questions or comments, I would like to ask Terrence Allen to come up to speak. We've been working with Mr. Allen and others on this hearing and also on various issues of interest in terms of medical cannabis. So, Mr. Allen.
Thank you, Supervisor Wiener. me just a moment to get settled here, if you may. While I'm doing that, I will say that your closing comments were quite appropriate in that the diversity of this new industry is really yet to be known. And as we begin to talk about how we're going to license it on the non-retail side, and we begin to explore what some of the pioneers in the industry have done to create business models that may look like what those license types are going to be in the future, you'll be able to see exactly how diverse this community of producers is, and in many respects, how invisible their businesses are. So I'll begin by saying that my presentation is not about medical cannabis dispensaries. It is not about a retail environment. It is not about the challenges that we have in trying to locate a medical cannabis dispensary in a neighborhood, which we have often seen. And I am encouraged when I hear Mr. Starr talk about creating findings for the Planning Commission so that when they begin to hear future cannabis dispensary applications, they have more than just the number of people that are there to speak out against it or for it to determine whether they say yes or no. So I find all those things encouraging. Fortunately, we have something different with non-retail. So good afternoon. I'm speaking today on behalf of California Cannabis Voice Educational Group and the San Francisco chapter of the California Growers Association. Thanks for holding the hearing. The Medical Marijuana Regulatory Safety Act, soon to have its name changed to the Medical Cannabis Regulation and Safety Act, simply because there's no plant named marijuana. There's a plant named cannabis, and we want science to direct the way in which our bureaucracy and our regulatory system talks about the plant. Let's use cannabis as the accurate scientific term and use marijuana when we want to tell the stories about our prohibitionist history. I'm known to some of you on the committee because of my advocacy around entertainment and nightlife, and for the past 2 decades, I did that. It culminated in the creation of the San Francisco Entertainment Commission, and then immediately following that, the creation of CMAC, or the California Music and Culture Association, which represents that industry. But my introduction to the political process started with cannabis and happened long before entertainment, when I met a man named Dennis Perrone in the summer of 1992. By literally taking me by the hand and walking me through the offices of the then supervisors, he showed me the power of direct citizen action. That day, I recounted to anyone who had listened to my story of having just been arrested for growing cannabis in my closet. Yes, arrested for growing pot in my closet, which I was using to help alleviate the side effects of early and unsuccessful AIDS drugs for my husband, who passed away shortly after that arrest. Cannabis was one of the few things that worked for him in the last of his years. After his death, I continued my medical cannabis advocacy in 1996 as a founding board member of the very first medical cannabis dispensary known as CHAMP, or Californians Helping Alleviate Medical Problems, CHAMP, and currently as the chair of the San Francisco State Legalization Task Force. And yes, we are taking up social justice issues. Yes, we are taking up zoning. And yes, we are looking at how this industry will look when we have further distinctions between just dispensaries and production. San Francisco should really show its leadership in cannabis by demonstrating to the state and nation how we can, in a thriving, dense, urban, mixed-use environment, have cannabis and have it work. Today, I ask you to focus not on the retail side, but on the non-retail side of licensing. We'll take the retail at another hearing. As was mentioned, a requirement for making an application to the state's dual licensing system is for the applicant to first provide a permit or statement of authority from the City and County of San Francisco in order for that state agency to accept the license. The state has given us a date certain of January 1st, 2018 for businesses to make that application, and or they will face cessation of operations. In other words, they won't be able to continue. So they either get there or they don't survive the first cut. So by working backwards, really now's the time for San Francisco to start getting our local permitting process in order. In failing to provide regulatory and permitting certainty, we will see many promising businesses move from the city to places that have done that in advance. And there are many that are attempting to get out in front of the cannabis industry by providing zoning and other incentives to have their businesses locate there. Regulation gives good, aspiring businesses huge incentives to become permitted and licensed. As I would say, let's harness the momentum. Let's use this as our call to action. You've heard how leadership in the DPH created a process to allow for the local production of cannabis in cultivation sites, that are all associated with MCDs, or medical cannabis cooperative dispensaries, and how those some 20 registered cultivation sites harmoniously operate today with virtually no complaints from their neighbors or from the police. Some of those cultivation sites are immediately sharing a boundary with residential uses, and still and yet today, after 2 years of operation, they produce no complaints. That's a pretty good example of a good neighbor. The state has given us a template for standalone licensing based on business type, and we can create a corresponding local approval process and activate the non-retail side of cannabis businesses where they are appropriate, as we heard from Aaron in his presentation in planning, and in so doing not only create incentives for where they should go, but advance this Made in San Francisco branding opportunity. Cultivation gives us an interesting glimpse into the reality of the black market. It is my estimate that there are at least 150 cultivation sites alive in San Francisco today. 150. We know of about 20. There are 150. They're almost all invisible to local authorities. None have been inspected, and none have been approved. And while we don't have a complete profile of those businesses, we have engaged in the beginning stages of a survey, which I will distribute to you now. That you can use for your reference. This gives you a general idea of the scope of these businesses and, most importantly, the workforce development opportunities. Many cultivation operations want to transition into a legalized and licensed tax-paying business, but some are located in buildings that are not in the proper zoning or are incapable of being brought up to code, and they will have to close or move. That's part of the reality. Some of the folks I talked to actually plan to sunset their business and not continue in a highly regulated environment. They came out of the days when this was the Wild West, cannabis was the substance that didn't require regulation. They stood there, and now that it's becoming regulated, it no longer fits them. They will sunset their businesses. And of course, some will consolidate, and others just are not going to make it through the regulatory eye of the needle. For me, the sorting begins with zoning appropriateness. In our desire and advocacy to see the city create a clear approval process to guide the evolution of our cannabis industry, to meet and exceed industry standards for best practices and for being active good neighbors. Cannabis compassion programs should continue as part of the agreed-to good neighbor policy to ensure financially vulnerable patients continued access to their medicine. We can use cultivation, the only non-retail cannabis business type, which can receive SF recognition, to pattern principles that we can apply to creating a pathway for each of the other 5 groups of non-retail license types. Simply stated, MCRSA divides cultivation and activity by size. The new multi-tiered state system challenges the existing capacity of the current registration through DPH, and it's now time to update that system so that it can accommodate the variety of new different cultivation license types. Why is this going on in San Francisco? We have very little land, and that is because cannabis grows well both indoors and outdoors. Cannabis cultivation in San Francisco primarily occurs indoors, where science has enabled master growers to optimize the conditions for the plant and produce a consistently fine product. They were all developed under threat of prosecution. So indoor cultivation facilities have created and borrowed sophisticated technologies and business practices which render them all but undetectable to their surroundings. In the case of A Good Neighbor, a business that exists, that produces taxes and jobs, that's undetectable, is a pretty good example of a good neighbor. But indoor cultivation has been proved in the 20 sites that have gone through the city's recognition process to be able to be permitted, inspected, and safe. And that should be our goal, create a system that all can go through. In manufacturing, a different issue. The state has created 2 license types for manufacturing, one volatile, one using non-volatile substances, as the distinguishing factor for when a business falls in the volatile manufacturing and when it falls in the non-volatile manufacturing. Fortunately, in San Francisco, as you heard from Mr. Starr, we have similar distinctions in our zoning code so that there will be a relatively easy transition when we're talking about volatile and non-volatile. It gets a little more complicated, however, because manufacturing creates an unlikely mix of products. It starts in manufacturing with a process known as extraction. And that's where everything from a non-volatile CO2 to a volatile substance can be used to separate the active cannabinoids from the plant mass, producing a highly concentrated and pungent molasses-like substance, along with a huge pile of great compost. The extracted product is potent and ready to be refined and transformed into just about any cannabis-based product you can eat, spray, dab, drop, infuse, rub in, vape, smoke, drink, put in your dog, send to the moon. Whatever it is, science and technology will show us where cannabis belongs. These product generation facilities resemble more small assembly plants and are all but, again, invisible neighbors and offer good-paying jobs and benefits. Third manufacturing type is where you produce things like medical rubs. They're great for arthritis, or a sublingual spray, great for quick uptake of the cannabinoid medicine. Shoe inserts. Anybody with shoe problems? Shoe inserts with specific cannabinoids in the insert that are allowed to transmit through the sole of your feet to ease arthritis pain and muscle tension. Amazing. And a thing called a vape cartridge, which 3 years ago I didn't even know about, but a vape cartridge is now the preferred, by 30% of the consumers, the preferred way to ingest cannabis. It's an almost smoke-free way to take this concentrate produced through extraction and refinement and give it to a consumer without having to have that consumer have a pipe and roll a joint and create smoke and create a problem for their surroundings. 3 years ago, didn't exist. Today, 30% of the market. Probably going to be a pretty big percentage. Businesses engaged in that kind of manufacturing look like just about any other light production facility, and again, have huge opportunities to scale, producing good-paying jobs which don't require a technical degree, just good work ethics, and showing up on time. Now, lastly, and also included in this large manufacturing license type, is my favorite, the creation of cannabis food, or what we generically refer to as edibles. A place for creating those products actually may very well resemble a commercial kitchen rather than a factory. When chefs are free to produce legal cannabis food in pairings, San Francisco's foodie culture will be able to write an entirely new Wikipedia section on medical cannabis food, and I hope we do. For me, San Francisco belongs at the forefront of that foodie culinary revolution with cannabis, and I think Medical Culinary Cannabis Institute of California, where even if the food isn't good, it still does the trick. Gotta let that sink in. There's another type of licenses which don't exist up until the state created them, and these were created as support service licenses in a large measure to help the state collect taxes. They make up 3 license types: transportation, distribution, and testing. The wonderful thing about this is that these businesses will fit into our existing zoning, where we already allow transportation facilities, distribution warehouses, and testing labs. Under MCRSA, no cannabis product can be purchased for sale by a dispensary unless it comes from a licensed grower. So this is part of the lockdown that the state regulation provides. It has to be transported to that dispensary by a licensed transporter. And all of that has to be organized by a licensed distributor, with the products all tested and labeled by a licensed testing facility. All of this happens with a tracking system to, among other things, establish provenance needed when creating appellations, like I said, such as made in San Francisco or made in Humboldt,
Terrence.
and to make taxes more easy. Yes?
You're losing us here over here.
Oh,
This
I'm
is
losing you. Okay.
So informative.
And I'm
but-
going to end by saying social justice opportunities. And I don't want to end by cutting that short. We need to incorporate social justice opportunities. We're coming from an incarcerated moment. We need to transition those people. I've been saying over and over again in my presentation that these jobs don't require special skills. Why don't we set up training programs? Why don't we reach out to our partners in the unions and ask them for apprenticeships? Why don't we go to the Drug Policy Alliance and ask them for guidance? We can do that. That can be a smart thing that we can do
Fair
with
enough.
an industry that starts at 15 and averages about $25 an hour.
I know that's actually one of the things that I'm most interested in, and I wish your presentation focused a little bit more of the workforce education and training component earlier in the presentation, only because we still have a few more items that we got to get to that are just going to be just as long. But I just want to say thank you. You've painted quite a vision for us to aspire to. I had no idea about the insoles. That's quite a phenomenal idea. I've just learned so much in the probably the one year that I've been studying up on this particular topic. And with that said, I want to recognize your leadership. It's been tremendous.
Supervisor.
The task force has been, I think, going to be a tremendous asset, not only for San Francisco, but the entire state. And I'd like to say across the entire country, although we're not the first state to begin to legalize adult use. So I'm sorry to rush your presentation.
No,
Are there
that's
any
quite
other
all right.
key points that you need to tease out for us?
I think I would just like to close by saying that right now, like never before, you've got the full attention of everyone that is aspiring to be a legal participant in this new cannabis industry. Let's not lose this moment when we can, in a call, get everybody together and get them to participate along with our city partners in crafting regulations, rules, zonings, and best practices so that these can be good neighbors and that the industry can participate so the regulatory system is doable and makes sense. Let's capitalize on this moment. Let's do it now. Let's do it in parallel with our task force working on adult use regulation, and let's start that non-retail conversation right now.
All right. Well, let's go ahead and start that conversation with going to public comment at this time. I have several cards here in front of me, and if you have not filled out a card, that's okay. We'll have an opportunity for you to come up and speak in public comment. Yes, after I've called the folks who have turned in cards. First card I have is Harold Joseph Smith Jr. Second, I've got Matt Osborne, followed by Brian Brooks, followed by Charles Head, then followed by Luke Bruner, Elisa Hambrecht, Ron Brandon, and Chris Emerson. If you could all line up in that order. Thank you so much. And we can go ahead and start with you, Mr. Smith. Harold Joseph Smith, you're first up. Welcome. And again, just as a reminder, everyone will have 2 minutes.
Thank you so much,
Thank
Supervisors.
you.
I appreciate your having this hearing. I am the owner of an ancillary business that concentrates on the information technology, or IT, side of the cannabis industry organizations. I am rolling out my LLC by being a compliance shop from an IT perspective for cannabis industry organizations. I won't speak long, but I will say that I am very much in support of everything you are doing, everything City Hall is doing, and everybody in the medical marijuana, or excuse me, cannabis adult and medical community is doing. I want to let you know that I have received marvelous feedback from my colleagues in the industry, and I want to make sure that I have a chance to be involved in the process and to help guide and shape the way cannabis is going to go forward from here, from a technological and social perspective.
Great.
Thank you.
Thank you. Next speaker, please. Come on down.
Hello, my name is Matt Osborne. I represent a group called the Safer Lower Hate.
Pull the mic to your mouth a little bit, Matt.
Sorry. I'm here today because many reasons, but the specific reason I came today is I'm hoping to request that the Board of Supervisors of this committee will look into the grandfathering clauses of MCDs. Specifically for us, the Lower Hate is in the process of having one attempt to come in. Grandfathering has essentially not allowed a public hearing before the Planning Commission. The neighborhood has not been able to speak. I'm not really for or against marijuana dispensaries in general. That's not the issue. The problem I'm having with this is that there's a specific case of people not being allowed to speak and have their voices heard because of an issue that essentially 10 years ago something was grandfathered in for all kinds of rule changes, but without people being allowed to speak, I don't think people can feel that their voices matter. To that end, I also have something I'd like to hand out to the...
Sure, I'm going to take it. Thanks, Scott. Thank you.
Okay.
Do you have more? All right, thank you. Next speaker, please.
Good afternoon. My name is Brian Brooks. I work with Matt on this group, Safer Lower Hate. What he just showed you right now is a storefront for the 473 Haight Street location, and I think what Matt was going to describe there is you have quotes from the board, the Planning Commission, in favor for this project when it hasn't quite been passed yet. Again, Matt mentioned, and we feel as a neighborhood organization that we were not informed about this project because it's grandfather clause, and this was given back in 2006 for a notorious MCD back then. You talked about clustering. The Lower Haight was a neighborhood that had a lot of clustering. We had 4 to 5 over the past 10 years. They've all closed in the past year, and the neighborhood is safe and walkable. We are asking for this committee to look into those issues of grandfathering in, because it was basically auctioned off to the highest bidder, and this is how this project is moving forward. There was no automatic DR for this, from planning to health, and the neighborhood was not informed. I'm actually for medical cannabis. My mother passed away. She was on chemo, so I just looked for this committee to look into the grandfatherness of some of these certificates that were issued back in 2005 that are up for auction right now.
Okay, thank you. Why don't you, Mr. Starr, could you talk to this gentleman a little bit about grandfathering and hear him out and see if there's a remedy? Next speaker. Sir, Mr. Brooks, this is Ken Starr from the Planning Department. He'll be able to help answer some of your questions about grandfather. Aaron Starr, sorry, not Ken Starr. Aaron Starr. Sorry, wrong Mr. Starr. Okay, next speaker.
Hello there, supervisors. My name is Luke Bruner. I'm from Humboldt County, and I have had the privilege of working on this issue as a rural community organizer for the last several years. In the letter I handed out to you, I give a bit of my credentials on the matter. I co-founded a 1,000 Farmer Strong movement in Humboldt County. I served as the legislative chairperson for the California Cannabis Industry Association during the MRSA process, and have worked extensively in the industry. I'd like to speak about two quick things. The first is, of course, transportation and distribution. On the back of these comments, I have written a very short, brief fact sheet that what seems like perhaps a thorny topic isn't quite so thorny. This is where the bulk of the jobs are going to be. This is where a lot of the jobs are going to come from, is transportation and distribution. I don't think we're going to be able to automate too many of those because this is still a risky controlled medicinal substance. Additionally, I want to speak to social justice issues, and it seems like this is very interesting to this committee. I've bolded two statements. Firstly, these new approaches are unburdened by certain negative historical precedents that are present in other industries. In other words, you're not going to necessarily fight a headwind here. Just like there's many particular social justice issues, there's the larger social justice issues of commerce itself. Perhaps the pursuit of money in a way that harms others is the cause of many social justice issues. And so there's a great opportunity to approach these justice matters as if we were creating capitalism anew, because this is a wholly unregulated industry. You are now regulating it for the first time in 2016. We can give preferential processing or other treatment to things like workers' co-ops, LLCs, benefit corporations, ag cooperatives, consumer cooperatives, and others. Here is an opportunity to set a new precedent for how cannabis business, and in fact all business, should be conducted. Thank you for your time and consideration today.
Thank you, Mr. Bruner. Next speaker.
Good afternoon. My name is Alyssa Hambrecht. I am a supporter of legalized, regulated, and appropriately taxed medical cannabis at the market and non-retail businesses so that the product can be made safe in a permitted licensed facility. The most important thing here is that the products are understandable to consumers. They're made in a consistent quality with standards, and they're clearly labeled for use of patients. Additionally, I strongly believe the revenues derived from the legally controlled marketplace are for societal good, delivering income from taxes that can support research, education, and other programs to benefit society. I'm a big proponent of legalization and ending prohibition for all of the social justice implications, namely lowering incarceration rates and freeing those that are currently incarcerated for nonviolent marijuana crimes. Professionally, I'm a serial startup entrepreneur with deep experience in the wine industry. I have served as a CEO of a 200,000 case permitted facility in Sonoma County, as well as a founder of a direct-to-consumer wine online marketplace, amongst other companies. My current startup is focusing on delivering professional compliance services for cannabis producers, growers, producers of edibles, any cannabis-related product. It is my theory that cannabis will be regulated in a capacity similar to wine and spirits. It's super important that the producers procure the right permits here in San Francisco as well as at the state level. And our business would not only help them procure and maintain these licenses, but also pay their excise taxes. On the personal front, I'm the mother of 3 kids. I live here in San Francisco, in Cole Valley. I'm a firm believer that legalizing and destigmatizing cannabis is the key to raising kids with a healthy attitude and behavior that pertains to this plant. Let's work together to make sure that this plant is for positive and transformative change here in our community, at the state level, as well as in our nation. Thank you.
Thank you. Next speaker, please.
Good afternoon. My name is Ron Brandon. I'm a former professional football player, certified firefighter EMT in the state of California. I attended college here in the Bay Area at San Jose State University, where I majored in radio, television, film. I am now founder of a company named Kingston Royal, a full-service cannabis management and consultant company that specializes in cultivation. So 10 years ago, when I retired from pro football, I found myself at a crossroads. I ended the season with a knee injury that needed surgery, and I had to make a decision whether or not getting surgery and going back to play was the best thing for me to do, or whether or not I got started with my professional career. When I first heard of the medicinal benefits of medical marijuana, I was skeptical. At the time, I was taking painkillers daily to manage the pain, but desperately needed an alternative. The pills were starting to make me sick. Within 1 week of medicating with medical cannabis, I felt amazing. Not good enough to go back and play, but simple tasks like getting out of bed in the morning were easy once again. That's when I got involved with cannabis. And started doing my research and started meeting others who believed in the medicinal benefits of medical cannabis. That's why today is a very important day for my team and I, as we plan to apply for a Type 2A license for indoor cultivation at the state level in 2018. But in order to apply for MRSA licensing, we need to receive an official local permit that the state recognizes in order to apply and still stay in business here in San Francisco. If this doesn't happen soon, personally, the loss would be devastating, and that's why defining these regulations are paramount. Without a clear and fair system to get locally permitted for cultivation, we would be forced to move our businesses out of the city to where local jurisdictions are permitted for marijuana businesses. Please support our request to work with the city agencies to develop an appropriate local permit system that encourages people like me who have a dream to take care of our family and our community. Thank you.
Thank you. Thank you very much. Next speaker, please. Come on down.
Good afternoon, supervisors. I'm Dr. Chris Emerson, co-founder and chief scientist at a cannabis manufacturing company based here in San Francisco. I'm here to talk about the manufacturing component of the cannabis industry. Although I've been trained in and worked in the pharmaceutical and biotech industries, my true passion lies in plant-derived medicines. I've witnessed firsthand how cannabis medicine can provide safe and efficacious treatment for a multitude of human pathologies. At the heart of this was the 2 years I spent providing my mom, who had triple-negative breast cancer, with cannabis products that I formulated for her. These products would now fall under the regulatory framework of manufacturing. The two types of manufacturing 1 and 2, in the state are contingent upon us being able to show that we have been operating in San Francisco in compliance with local ordinance. Currently, there are significant challenges in interpreting and navigating the nebulous pathway necessary to demonstrate compliance with local ordinance. At this time, we are currently engaging with both DPH and the Planning Department to try and determine which permits we actually need to apply for in San Francisco. This hasn't been an easy process to begin, nor to work through, and without my prior knowledge of building out facilities, we wouldn't have gotten this far. We welcome an open and transparent permitting process. Without local permits, our ability to raise outside capital in order to scale operations is very challenging. Scaling operations not only involves investment of significant capital in building and equipment, but in hiring and employing local SF residents. The manufacturing jobs don't require advanced degrees, such as a PhD, or advanced skill set, such as software development. All they require are for individuals who are hardworking and want to make a difference. Operators who aren't able to get permits in a timely fashion will be forced to either close down or move out of San Francisco. We are a San Francisco company. All of our founders and employees live in SF, and that's where we'd like to remain. Thank you for your time.
Thank you. Next speaker.
My name is Jeffrey Kolsky, and for the last 10 years, I've actually, it's very hard to kind of say this, but I have basically operated within the undefined realm of the patient cultivator and the manufacturing. So a number of years ago, I began making an edible in a home, and it's just a difficult thing. So there are no regulations for manufacturing at all in San Francisco. What we have basically been asked to be and remain is with the closed loop system as a patient cultivator. In essence, I have operated out of a small home, and with basically discussions with Larry Kessler over the years and various people at the DPH, that was the only way that an edible could be made in San Francisco and then brought to multiple dispensaries. You cannot have a medical cannabis dispensary, make a product in that, and then distribute to another dispensary within San Francisco. So there has been a very fuzzy place where I have made a statewide brand very quietly out of a private home in San Francisco, which basically falls into the closed loop system that has existed up until now, MMRSA. MMRSA is developing the entire framework for manufacturing, extraction, cultivation, doing extremely heavy lifting, and all of the industry leaders that I've been meeting with, manufacturers, Kiva, large brands, extractors, have basically been sectioned off to agricultural department for cultivation and then to the Department of Public Safety in Sacramento. We have been presenting white papers to the state to basically help guide MMRSA, which would be basically the entire framework which is completely non-existent in the state, and which IUMA would then have a huge leg up to work with and then have infrastructure. So within a very short period of time, we are being asked to create an incredible amount of infrastructure and recommendations to the state. San Francisco really, I hope, gets on board with the manufacturing as well as many of the cities like Oakland, which has taken a number of the small original startups like Auntie Dolores, as well as...
Okay, I'm going to have to stop you. Your time is up. Thank you.
Well, thanks.
Next speaker, please.
Good afternoon, ladies and gentlemen. My name is Mookie Walden. I'm a cannabis consultant from here in San Francisco. My business partners and I, about 2 or 3 years or so ago, started a cannabis consulting business and a trimming company to help assist the growers. A little bit of background about myself. We've been working hand in hand with the dispensaries here in San Francisco for around 10 years. 5 years or so when we were still actually working with the dispensaries through the relationships that we developed through the growers and the actual dispensary owners, we actually decided to kind of tailor make our business to kind of help the growers. And just quite simply, our clients, our growers, the dispensary owners, we kind of help them with everything from training and manpower with their employees to logistical issues so that we can allow them to just simply focus on continuing to grow great medicine. My main concern is just a small business startup here, is just making sure that the regulatory process doesn't tax out the smaller people like myself that are actually trying to go through the legal process and do things correctly. I know that there are some other cities here in the Bay Area that are in some ways a little bit more their laws are a little bit more ahead of the curve, and I want to make sure that because San Francisco has been so great to us and this is where we have our startup, that we could hopefully still stay here and grow our business with the economy here in this city.
Thank you. What was your name?
My name is Mookie Walden.
Thank you.
Thank you.
Next speaker.
Good afternoon. My name is Aaron Flynn. I served in the United States Marine Corps for 4 years with the combat tour in Iraq and Afghanistan in 2003 and 2004, respectively. As I exited the Marine Corps, I was suffering from a variety of different post-traumatic stress-related issues, and while the VA really tried to help by prescribing prescription drugs, I found that cannabis really helped more than anything else. It helped myself personally, it helped a lot of my brothers in arms, and that's when I decided to get into the cannabis business. I've been doing it since 2004. I've been cultivating since then. I've been cultivating in San Francisco with a Class 2A license since 2010, and I'm proud to say that I'm one of the facilities that's on that DPH list, the 20 facilities. My facility employs 3 other veterans, contributes products to veterans, and donates proceeds to veterans and other organizations that we feel strongly for. My fear is that in 2018 I won't be able to continue to operate my business here in San Francisco. I live here in San Francisco, I operate in San Francisco, I love San Francisco, and I want to stay in San Francisco. I strongly urge the committee to direct staff to begin the process to create standalone licenses that cultivation sites like mine and others will need in order to continue to operate past 2018 here in San Francisco. Again, I want to stay here, I want to scale my business here, I want to continue to create jobs here and continue to prosper and create more jobs for those that need it. So thank you for your time.
Thank you for your time and your service. Next speaker, please. If there's anyone else that'd like to come up and speak, I just have one less speaking card. Alex Zavel.
That's me.
All right,
Thank
come
you.
on. All right. Please.
Thank you, supervisors. My name is Alex Zavel. I'm a regulatory analyst with the law offices of cannabis attorney Robert Raich. I'm also a policy advisor to the California Growers Association and the chair of the National Cannabis Bar Association's Committee on Local Policy and Regulation. In these roles, I work with the state government, its agencies, and local governments across the state to implement regulations for the medical cannabis industry. I wanted to thank you all for your time today to hear about this important matter. As you've heard from city staff as well as other speakers, the state is undergoing a groundbreaking transition in how it regulates this industry, and San Francisco has an opportunity for leadership on this matter to bring San Francisco's longstanding history of leadership on this issue into conformance with the new regulatory structure that's been imposed by the state. Mostly, I just wanted to speak to request that this committee direct the staff to work further on developing specifically a non-retail permitting structure. As you've heard previously, the city has been regulating the retail dispensary component of the industry, but has largely only indirectly and informally dealt with where the cannabis products sold at these dispensaries comes from. Now is the opportunity the opportunity and real requirement for the city of San Francisco to act to create a formal permitting structure for these particular non-retail business types. I would also request that you, in directing staff to do that, ask them to continue their dialogue and request participation of businesses who operate in this industry to ensure that we have a regulatory framework in the city that works for all and ensures that this essential medical product can be available to all that need it. Thank you very much.
I appreciate your testimony. Thank you very much. Ladies and gentlemen, are there anyone else that'd like to speak on this item? Please.
Yes, I'd like to say that actually MMRSA is illegal. It was against the voters' will. The voters did not pass this. It's against the California Constitution. And I disagree with any law that, Prop 215 showed that there really are very few dangers associated with cannabis. It illustrated, we legitimized the community so that everyone could take it away from us. I suffer from a life-threatening illness, and Prop 215 probably saved my life because I could get free cannabis. And, my Lyme disease treatment costs $600 a month, and I get $950 every month. So I have very little to live on. And it just seems like the callousness of this law is just beyond belief. It's really not. It's only helping to line rich white boys' pockets. It seems like. Please. I wish I was wrong about this, but that's practically all I really have to say. There's just too much to say in 1 minute, and
you have two.
Good. Well. Thank you. And I wanted to say that 99 plants is appropriate for patients to grow for one another. If we can't grow for one another, how can they call it legalization? And I don't understand why cannabis is a life-saving substance, has killed no one, has to be regulated like alcohol, and even pharmaceuticals kill 100,000 people a year. So why are we being over-regulated? I'll tell you why. To justify greed. That's why. And market takeover. That's all it's about. That's all it's ever going to be about. And we've tested this substance. I've done all the research I need to do. It saved my cat's life. My cat should have been put down in February. I've been giving her the oil every day. I need to grow a lot of more than 6 plants a year to save my life. Thank you.
All right. Is there anyone else that'd like to share their thoughts, their comments? No? All right, I'm going to close public comment and want to just take a moment and thank everyone that took time out of their busy day to come and participate in this conversation. The task force has a lot of work ahead of them, as do the ballot initiatives that are going to be coming before us in November. I do want to encourage everyone that's at the table to continue to do the work needed. I personally am committed to this discussion, and I would love to, and I will be working to ensure that there is certainly equity in access and equity and opportunity for everyone. People that want to remain in San Francisco should have a viable opportunity and a vehicle in order to remain in San Francisco. Also want to recognize the fact that those businesses that are offering kind of in a gray or a shadowy area, we want to work to bring them out from the shadow and into the light. Supervisor Wiener, I appreciate you for sponsoring this hearing. I'd love to just add my name as a co-sponsor. Great. Thank you so much, and I'll turn the rest over to you.
Thank you, Madam Chair, and thank you again for calendaring this. I want to thank, first of all, our city department for the really thorough and thoughtful presentations. I think a lot of times for our department it's challenging and at times frustrating because you're required to administer a law that is really, frankly, incomplete and not necessarily out of the year 2016, and really trying to regulate an industry that is dramatically different than it was even 5 or 10 years ago, and then having to really deal with the clustering, green zone, red zone issues, which I know I think the Planning Commission has been yelling at us for years to deal with it, and the board and the mayor have not. We've not dealt with it in the way that we need to. And so I know it's a challenge, and I appreciate the work that our city departments have done, and we're in a time of real change in terms of the recently passed state medical cannabis legislation that we talked about earlier, and then the possibility, I hope probability, of adult use legalization in November. We really need to make sure that we in San Francisco are staying ahead of the curve instead of at times falling behind. And so the adult use task force, legalization task force that's currently doing its work, I think will be really helpful. And we need to just make sure that we keep the momentum going for both adult use, if and when that happens, and medical cannabis. And I want to just really emphasize what I talked about earlier and what came up a number of times during public comment, that this is not simply about the traditional MCD model. Yes, MCDs serve an incredibly important purpose for many, many people. MCDs are really, that is the access that you have to your medicine. And we need to make sure that people have access to their medicine. But we also need to acknowledge that the medical cannabis world is so much larger than simply MCDs. And we have to bring the law and our regulatory structures into the modern world to recognize what this industry is, what this community is. When regulations fall behind the state of an industry, we end up just encouraging a black market, creating a situation where businesses that are good businesses, that want to be legal, that want to play by the rules, that want to have all the right permits and pay their taxes, aren't able to do so, and have to do workarounds that are not in those businesses' interests, and just creates stress and challenges for them. And it's not in the interest of the public, because we want to make sure that we actually have these businesses in the sunlight. So we have some catch up to do, but I know we're going to do it, and I look forward to that work. So, Madam Chair, with that said, I would move that we file this item.
Thank you very much. Without objection, the motion passes. All right. All right, ladies and gentlemen, thank you very much for your time. Staff, thank you for your time as well. We're going to move on to the next agenda item. We're going to call item number 8 first, and then we will call item number 7. So, Mr. Clerk, could you call item 8?
Item number 8, ordinance amending the planning code to allow the construction of accessory dwelling units on all lots in the city areas that allow residential use, amending the administrative code to revise the definition of rental unit as it applies to ADUs, affirm the planning department's determination under the California Environmental Quality Act, making findings of consistency with the general plan.
Okay, Supervisor Peskin is the author of this item and will be leading the discussion here forward.
Thank you, Madam Chair, and thanks to those individuals who are here to testify, and thank you for your patience. This citywide accessory dwelling unit legislation is, I think, another step forward to create more housing units that are both affordable by design as well as subject to rent control, and it's something that can be done without drastically altering the look and feel of our neighborhoods and without the threat of displacing existing residential or commercial tenants. This is part of an evolving field of law that dates back many decades. There are any number of supervisors who tried to legalize in-law units, as they were called at the time, or secondary units. Supervisor Terrence Hallinan, Supervisor Mabel Tang. Over a decade ago, I actually introduced legislation that did not succeed, but the world has changed, and since that time, our colleague, Supervisor Scott Wiener, has led the way with legislation that first was for portions of District 8 and ultimately for all of District 8, and then my predecessor did legislation for District 3. I've always been as much as I was delighted to see those pieces of legislation move forward, I was always puzzled by the notion that we would be doing legislation on supervisorial district lines. I mean, look at District 3, which has downtown and Fisherman's Wharf and Chinatown and North Beach and Polk Gulch and the Upper Tenderloin and Nob Hill, very, very different land uses and land use types. But I think the time for citywide secondary units has come, and so I wanted to build off of the work of Supervisor Wiener and my predecessor and see if we could take this show across the city. I want to thank supporters of the legislation, many of whom are in the audience, including the San Francisco Apartment Association and the Housing Action Coalition. Recently, as I think folks know, one of our colleagues proposed similar legislation for the ballot, and I am hopeful that we can discharge the duties that we were elected to do, which is to legislate here in these chambers, and by doing so, allow us the flexibility to continue to tweak this kind of law as this field continues to evolve. I am prepared to make a number of amendments, many of them clerical, some of them clarifications. And colleagues, I have for you amendments that I will distribute and describe to you. Rather than hand you the entire 100 and some odd piece of legislation, all of the changes are in the first 12 pages, so I will hand those to you. As I said, many of them are just clerical amendments, but relative to more substantive amendments, one is that I actually followed Supervisor Wiener's lead in his District 8 legislation relative to the number of units that would be constructed, namely, copying is the best form of flattery, Supervisor Wiener, so I copied you, and that was to have an additional 1 unit in buildings of 1 to 4 units and 2 in buildings over 10. Is that right? Is that how we started?
I think it was 1 up to 10.
1 up to 10 and 2 over 10. Subsequently, the legislation that was done for District 3, was 1 for buildings of less than 5 and unlimited over 5. And so the amendments that are before you actually go with the District 3 more liberal, more unit legislation, which I think is appropriate given the magnitude of our housing crisis. But I do include language based on the Mayor's Office of Housing Standards relative to the minimum number of square feet, which for a studio would be 350 square feet, and for a 1-bedroom, a minimum of 550 square feet, so that we're not building teeny tiny rabbit warrens. There's also a provision to clarify that landlords are not precluded from setting initial rent. There was some concern that these new units, which by regulatory agreement would be subject to rent control, would also be subject to vacancy control. That was not the intent, and there's clarifying language in the amendments that I've put before you. I am, in my desire to try to get this done in these chambers, willing to make other amendments that will allow it to receive widespread support by a majority, if not a supermajority, of the Board of Supervisors. And with that, Madam Chair, given that I know a number of individuals who want to testify on this matter need to leave shortly after Supervisor Wiener, maybe we could open up to public comment and then have a frank discussion. I know Kimia is here from planning to say a few words.
Okay, before we hear from planning, let's go to Supervisor Wiener, hear his remarks. We'll go to planning, and then we will hurry and get to public comment.
Great, thank you very much, and thank you, Supervisor Peskin, for that overview. This has definitely been an evolving process, and actually when I started my work on the original District 8 sort of tiptoeing back into the new ADU debate, we actually started off with the legislation that you had done about 10 years before. So this has been definitely an evolving process, and it's great to have a lot of different brains involved. And I think it's overdue for us to broaden this out. I think we're making good progress, and I think frankly the political landscape has shifted. That 10 or 12 years ago, sadly, you were unable to convince a majority of colleagues to pass it, and now the several pieces of legislation have passed because we know the magnitude of our crisis, and housing does not allow us to simply do things the way we've always done them. Thank you for making the change in terms of acknowledging that for larger buildings, there should not be a cap on the number of units. It just makes sense for how much space there is in the building. I appreciate that. Two things I want to note, and I look forward to reviewing this more carefully after today. One, in terms of the seismic ADU legislation that I authored a couple of years ago, which says that if you are seismically retrofitting your building, whether it's mandatory or voluntary, and these tend to be apartment buildings, not single-family homes or even two-unit buildings, that you can add units. That program has been really successful. We've had around 100 or almost 100 permits pulled, and it's just a wonderful synergy between seismic safety and creating new housing, often rent-controlled housing. I would like to see the seismic ADU program remain as part of this legislation entirely intact in its current form, because I think it's working and I don't want to do anything to disturb it. I also am curious to know the rationale for requiring that the unit be at least 350 square feet for a studio, 550 for a one-bedroom. The minimum unit size in San Francisco is 220 square feet per the micro-unit legislation that I had authored, I think, 3 or 4 years ago. I would hate to see a situation where someone has space of, let's say, 220 or 250 or 300 square feet, and they're prohibited from creating a unit. Because I understand the desire to have somewhat larger, but I would just hate for someone who wants to create a unit to be unable to do so. So I would like to continue that conversation. So as you know, colleagues, Supervisor Farrell and I have separately pending legislation where there's a good deal of overlap with Supervisor Peskin's legislation, but differences. The amendments today seem to be a step in the right direction. It is my hope, and I actually spoke with Supervisor Farrell this morning, I know it's his hope as well, that we're going to be able to come together and come up with one product and move forward in a unified way. I think this is a step in the right direction, and we'll have continuing dialogue, I know.
Thank you, Supervisor Weiner. Let's go to the staff presentation.
Good afternoon, members of the Land Use Committee. Kimia Haradam, Planning Department staff. The ordinance was before the Planning Commission on June 16th. The Commission recommended approval with modification with a 4-to-1 vote. We thank Supervisor Peskin for taking this initiative to expand the ADU program citywide. Allowing ADUs is an important infill housing strategy that would convert existing unused spaces in our existing residential buildings into new, much-needed housing units. Starting in 2014, Supervisor Weiner spearheaded a series of ADU ordinances that created a specific definition of ADUs in our code with certain controls and restrictions. Since then, the department has received over 70 applications, including 130 units. Majority of these units are within the buildings undergoing soft story seismic retrofitting, which is the most successful ADU program we've had to date. The Planning Commission recommended 4 modifications, one of which was the one that Supervisor Peskin just made. The modification, the Commission recommended to remove the cap on the number of ADUs allowed per lot in mid to large size buildings 5 or more units, and maintain 1 ADU per lot cap for smaller buildings less than 5 units. The Commission also recommended establishing a minimum unit size. At the Planning Commission, we discussed the average unit sizes that we've been seeing in the ADU pipeline. I put this summary table on the overhead projection.
And my recollection was the average unit size you've been seeing is about 600 square feet?
It's about 600 square feet, and for a studio, it's about 375 square feet, and for one bedroom is again 600 square feet. So these averages are, again, both above the minimum sizes that you discussed right now.
And relative to Supervisor Wiener's, I think, interesting point, which is somebody who has less. I added the minimums really as a result of lifting the cap, right? So, but he's raised an interesting concept, which is, let's say you're a building under 5 units and you've got a spot that's 240 feet, and this would presumably preclude it. Maybe the way to nuance that, Supervisor Wiener, and maybe Kimia, you can share your thoughts with us, is that would only apply in buildings over 5 units. Because presumably those are the ones that have larger amounts of space where you'd want to create the minimums. Yeah. But it sounds like on the studio size we're above the minimum average, and on the 1 bedroom we're above the minimum average.
Yeah, and I guess this is, and I think that's a step in the right direction. I guess at some point there's also sort of a philosophical, discussion of we also want to have more units rather than fewer units. But I imagine we can work something out on that.
I guess the point that I was trying to raise is that in the pipeline that we've been seeing, we are not seeing many super small units, so it's not a problem that we should, even though in the seismic retrofit buildings there's no cap, people are not building smaller units. So if that situation arises, it would be great to have that unit, to have the smaller size unit, but it's not going to be, we're not going to have a lot of smaller units because we haven't been seeing it so far.
Yeah, I will also say what's interesting is when I authored the micro unit legislation, whenever that was, 2012, I think it was, maybe 2013, I know there were all sorts of concerns expressed across from different parts of the political spectrum that this would just proliferate and we would become a city of micro units. And so there was a cap placed of, I think, 350 regular market rate micro units with no cap for student housing or affordable housing. And we have not yet hit the cap for market rate micro units, although I know there is student housing separate from that's been going on, and also affordable housing, which are the two probably most common scenarios where we're going to see micro units. So I think we've seen, in terms of the market, there's always going to be a space for micro units, but I don't see it becoming in any way a dominant type of housing unit. I think it's just sort of one piece of the overall pie.
Yeah, I would agree with that from what we've seen so far in the pipeline. So the second recommendation was...
Just one other thought on that, which is in the case that Supervisor Wiener is speaking to, perhaps there could be a provision, a hardship provision, where the zoning administrator could vary it in certain circumstances. Just a thought.
So the second recommendation is to clarify that existing built envelope includes spaces that can be filled in currently without notification as listed in the Zoning Administrator Bulletin number 4. The proposed ordinance, Supervisor Peskin's proposed ordinance, maintains the current restrictions on space use for ADUs, so ADUs have to be within the existing built envelope. The Commission recommended allowing ADUs to be built within spaces under bay windows, under cantilevered rooms, and the like. And these spaces are listed in our ZA Bulletin number 4 as type of spaces that expansions to them would not be subject to notification. Expansion into these types of spaces is already exempt from notification, and it's key to making some ADUs that are currently infeasible because they cannot meet the exposure requirements, and it would make them feasible. The third recommendation was basically just to further study allowing or prohibiting ADUs to be subdivided and sold separately, especially in condominium buildings. We had a long discussion at the Planning Commission hearing about this, and the result was to study this further. It was discussed that the condominium ownership structure already maintains complexity for adding ADUs. Prohibiting ADUs from sale would only add to this complexity and would significantly discourage owners of condominiums to convert their unused spaces into new housing units. Similarly, a single-family homeowner may not choose to add an ADU if they know that in the future they cannot sell it separately. And then the last recommended modification was just a slight correction in section 207C4, land number 4C, which allows buildings to be raised 3 feet if they're adding a ADU, and it currently refers to an incorrect section in the building code. It refers to Chapter 34B, which only talks about soft story seismic retrofitting, and so we recommend to make that correction to refer to Chapter 34 of the building code. So the building code only allows buildings to be raised 3 feet if they're doing full seismic retrofitting at all levels, and Chapter 34B only talks about soft story. So that last one is just a correction for the reference. That concludes the Planning Commission's recommendations, and I'm here for any questions.
Thank you. Colleagues, are there any questions? No? All right, let's go ahead and go into public comment. I actually have 4 cards in front of me: Charles Head, Tom Radulovich, Catherine DiVincenzi, and Eileen Boken. If any one of those speakers are here, please come on up to the podium. And if I didn't call your name, please come up.
And by the way, I just want to say that part of the technical corrections had that Chapter 34.
Great. Good afternoon, Supervisors. Tom Radulovich, Executive Director of Livable City. We're big believers in in-law legalization and the potential of in-law units to add to our city's housing stock in ways that make a very minimal or even a positive impact on neighborhood character. To add more rent-controlled units. This may be the only legal way to add rent-controlled units to our city. So Supervisor Peskin, we thank you for bringing this forward. Supervisor Wiener, you as well. You've both been real leaders in this. We appreciate also the amendments that you brought forward, Supervisor Peskin. We think this make it a better ordinance. Some of our concerns are, well, let me just say, we're very much in support of what the Planning Commission brought forward in terms of their amendments, the idea of clarifying the existing building envelope to include things like infilling in light wells or under projecting stories and those sorts of things is good clarification. This is going to allow these units to be a lot more habitable, make it easier to meet the exposure requirements, and is going to have little or no impact on neighbors or on loss of yards and those sorts of things. So we think it's a good addition. We also agree that there should be no additional restrictions on the seismic program. It's been very successful. I believe it's been fewer than 10 units created under the District 3 and 8 ordinances, but at least 130 are approved under the seismic program. So, keeping no limit on the number of units, no limit on the size of units, although you might just default to not the micro unit size, but the minimum unit size is not a micro unit. I believe that's like 275 square feet or something. So maybe just make it as small as a unit can be. That's not a micro unit. And then also notification for raising the 3 feet. That's something that's being added back, although it was an exception under the original ordinance. We agree there should be flexibility about the number of units per building. There's a lot of restrictions these have to meet. Exposure has to be within the existing building and all that. That forms enough constraints that you couldn't fill the whole ground floor with studios if you wanted to. So we think living within those constraints is probably.
Next speaker.
Good afternoon, Supervisors. I'm Kathy Devinchenzi, and the housing element of the general plan does not support the proposed ordinance because it would have citywide application, and the extensive community planning process required by the housing element has not occurred. Also, environmental review under CEQA has not occurred, and the EIR prepared for the 2009 housing element did not evaluate impacts of citywide zoning changes enacted without an extensive community planning process. Also, the city would act at its own risk if it were to approve this, relying, as they propose to, on the final EIR for the 2009 housing element. The legal sufficiency of that EIR is now being considered by the California Court of Appeal and has not been finally decided. So essentially, in 2004, the housing element policy changes took a citywide approach, but they were struck down and revoked for failure to have performed an EIR. And then, in 2009, the city decided to abandon the citywide approach and require community planning processes, and that is the hallmark of the whole document. And Policy 1.5 of the 2009 carried over into the 2014 housing element says, consider secondary units in community plans. And Implementation Measure 10 provides, at the initiation of any community planning process, the Planning Department shall notify all neighborhood organizations who've registered with the Planning Department on its neighborhood organizations list and make continued outreach efforts with all established neighborhood and interest groups in that area of the city. So that community planning process has not occurred, and that may be why it was done by district before, because the general plan requires outreach. And so the coalition hasn't gotten notice, the neighborhoods haven't gotten notice, and I'm sure that a lot of people would really like to have input on this. And that is the way the general plan is set up. The Planning Department Commission resolution admits that they didn't have the traditional planning effort. So now it's the summer, but I'm urging you to, in fact, engage in some kind of a community planning effort. So the potential impacts on land use character, zoning density, and neighborhood character also need to be analyzed and mitigated in an EIR. I know that some of these extensions that are being proposed could end up in the ordinance, and these could impact in going over the 45% rear yard line in RH2. And also, there are now news reports of a condo glut, and so it looks like the boom is turning. And so I'm wondering why, in fact, whether we should have some further study before we go citywide. I have the letter.
Next speaker. Come on, Tim. Or whoever's next.
Good afternoon, Supervisors. Tim Colon on behalf of the Housing Action Coalition. And I remember Supervisor Peskin's attempt about a dozen years ago on this, and it was a bitter pill indeed when it failed. That was the right thing to do then, and we commend you for bringing this back. We would very much like to see a robust ADU ordinance. Support for ADUs is in our founding DNA, in our founding mission. We are aware that there are two competing measures of this, and we would pray that the two could get reconciled and move forward as an ordinance. The best measure would be one that builds the most housing and gets property owners to do them legally. The city doesn't have a problem so much not building ADUs as in building them legally. And the proposed ordinance could be strengthened by the following. We think maximizing seismic retrofit incentives is the absolute logical way to do it. It gets it at the right point in the process and gives incentives for them to consider, property owners to consider building legal ADUs. I would agree with the remarks made by Ms. Haddad about condo ADUs. We would be concerned that not allowing that is a disincentive to moving forward with it, or certainly moving forward with it legally. I'd say that the micro units idea makes sense, and we have that in place. everything we see is getting smaller. We see studios much smaller than 350 feet commonly, and so we think that makes sense. And then the HAC remains committed to advocacy for new financial tools and educating commercial lenders on tools like home equity lines of credit. We would like to help in that measure. And then finally, we need a process of streamlining for permit applications and getting permits. We've heard stories that it's just too daunting. It's too difficult to get the permits to do this, and this would be part of getting incentives.
Thank you. And to Mr. Colin's comments, we have actually convened now a number of meetings between representatives of the building department, planning department, the apartment association, and others to affect some process improvements relative to the permitting, as well as to attempt to undertake an outreach program affirmatively to convince people that it is a good, smart, financially opportune thing to do. So hopefully we will launch that and not just pass a piece of legislation, but be proactive. Mr. Turner.
Good afternoon, Supervisors. Brooke Turner with the Coalition for Better Housing. I want to thank you, Supervisor Peskin, for trying to address this issue again, and Supervisor Weiner for your work on this part as well. You've both been very diligent in trying to get this done in the city, and we appreciate it very much. Not to outdo my friend Tim, but I can remember being here for the initial discussion of this with then Supervisor Hallinan so many years ago, and you can tell that by my beard. But here we are today, and now we have a plethora. We have 3 possible initiatives or pieces that could go forward. Our hope, of course, is that we'll be able to work this out and get one thing that can be done, hopefully here in this board chambers, and we look to you to try and facilitate that. Just a couple of things. One is that we are very supportive of maintaining the seismic rules and the abilities for seismic retrofitting to allow for these ADUs to continue. So we hope that won't be touched. And then the second thing, we'd like to make sure that vacancy control issue, that esoteric thing that's hanging out there, gets addressed within all of the legislation. So we appreciate your looking at that. Thank you all very much.
Thank you, Brooke.
Good afternoon, Supervisors. Fernando Martí with the Council of Community Housing Organizations. When I saw Tim Colin come up, I was excited that we might actually be on the same side supporting a measure together for accessory dwelling units. Unfortunately, Tim raised the question of condo conversions and brings me to the point of the devil being in the details and needing to make sure that we address unintended consequences. Supervisor Weiner, when you passed your legislation for micro units, very smartly included a limit, a cap, and an ability for the supervisors to come back and review what the consequences of that legislation were in creating a new market. What we want to do here, I think, has been part of the story since the Hallinan days of expanding naturally affordable housing that people who first arrive into the city can live in, where families can move into, and that is what this ADU legislation potentially can do, is to expand the amount of rent-controlled housing in a way that we have no other way of doing. However, if we allow these new units to be subdivided and sold off as condos, we are potentially creating a new market on speculation that would work absolutely against the intention of expanding our rent-controlled stock. So I just want to say we are fully in support of the ADU legislation as it is, as an ordinance, and I think all of you are probably very much against the idea of ballot box planning and would be supportive of coming together in a joint solution as an ordinance. Thank you very much.
Good afternoon, Supervisors. Janann New, San Francisco Apartment Association. First of all, I would like to thank Supervisor Peskin for introducing this legislation and working with all the interested parties in meetings about making sure that whatever we pass works out in the city. The first thing I'd like to say is I'm hoping that Supervisor Wiener, Cohen, and Farrell and Breed remove the ballot measure option, because this legislation, as you can see, is fairly complicated, and any changes that we decide to make now, today, or into the future should be made at this body and not on something we have to go back to the ballot on. I don't think any of us can afford to do that time-wise or money-wise. There's a couple of things that I would like to mention today. One is we want to make sure that there's no vacancy control in this proposal. We found a fatal flaw in it. Supervisor Peskin has agreed to fix it. We had our legal counsel submit comments. They've been distributed to all of your offices about getting that fixed through the city attorney. Unfortunately, the ballot measure has the problem. There's no way for us to fix it. That's one reason we'd like to get that removed. We'd like to maintain the seismic language that has allowed current ADUs to be built. We think that if ADUs are subject to rent control in rent-controlled buildings, they should continue to be subject to rent control, but not to vacancy control. We think that the ADUs that are not subject to rent control should be the same as in the building they are, in other words, not subject to rent control. We believe that the ability to create more units, that's already been taken care of in Supervisor Peskin's amendment. I think that's a good thing. We don't want to limit the number of units that can be added. I think as far as unit size, I think we should allow for as much flexibility as we can. Camilla indicated that the larger units are being added, but there's no reason, as Supervisor Wiener brought up, that a smaller...
And
Sure.
thank you, Janann, for working with my office. And I also want to acknowledge Lee Hepner of my staff, who's done the laboring or at our office.
Next speaker. Eileen Boken, District 4 resident. I would like to echo Ms. DiVincenzi's comments. Also, I'd like to advise the committee that Charles Head, who is here, had to leave for the civil grand jury. Mr. Head is with Sunset Heights Association for Responsible People. I personally am with Sunset Parkside Education and Action Committee. Neither of these organizations has received notice regarding ADUs. We look forward to receiving that notice. Thank you.
Good afternoon, Supervisors. Charlie Goss of the San Francisco Apartment Association. Thank you for bringing this item today. It's exciting for us to be able to work on something positive and to be able to construct newly rent-controlled housing, and we appreciate the opportunity very much. Continuing off of what Janann was saying, based on the way these buildings are organized, if somebody is putting together an application to create an ADU and the building's already been condoized, we believe that it makes sense to allow that ADU to be subdivided. If the building has not been subdivided by the time the permit has been pulled, it probably doesn't make sense. We also believe that there shouldn't be short-term rentals in accessory dwelling units. We had a question about permeable surface requirements and what the kind of nexus is and why that's exactly in the code. It seems that that could possibly prevent the creation of accessory dwelling units. We're not sure what the legal reason why that's in there is. I'm sure it's something, but I would hope that you could look into that. We've already addressed some concerns with your offices in writing with regards to the vacancy control, and we appreciate that being taken care of. And then just once the legislation is passed, if it gets passed, we're very hopeful that it will, we would want the city to also potentially look at the regulatory agreements that our owners are signing just to verify that they're in compliance with Costa-Hawkins and all of our local laws. But thank you.
Thank you, Mr. Goss.
Is there anyone else that'd like to speak? Nope. All right, seeing none, public comment is closed. Mr. Peskin.
Madam Chair, so let me take these in no particular order. I believe that the issue raised, albeit unintended by the author relative to the vacancy control, has been dealt with in the amendments offered earlier. With regard to the general plan issues that Ms. DiVincenzi and Ms. Boken brought up, I would like to defer to competent counsel in the form of Deputy City Attorney Givner as to whether or not that which is before us is general plan and CEQA consistent.
Deputy City Attorney John Givner. The Planning Commission in its resolution after considering this proposed ordinance made general plan consistency findings determining that the ordinance is consistent with the general plan. The Planning Department has also completed CEQA review, and the ordinance will affirm the Planning Department's CEQA determination.
Okay. Thank you for that. Now, as to the permeability issue, I will have to get with folks at planning, and I know Supervisor Weiner was the author of the most recent permeability legislation, so I don't know how to answer that. With regard to subdivision, I'm actually prepared to, in the spirit of trying to bring these two pieces of legislation together, to offer an amendment which I think is very consistent with the words that Mr. Goss just uttered, and that is that in buildings that are currently condominiums that as of today's committee hearing do not have a history of Ellis Act evictions in the last 10 years and have been a condominium that has been used, that's been a condominium for 3 years, that they could be subdivided. However, I believe that in the spirit of what we're doing on the rental side, which is having them be rent controlled, that we should ensure that these units, if they are subdividable and for sale units, should be subject to a BMR provision at 120% of area median income. So the amendment that I am about to offer would, in Section 207C4E, starting at page 7, line 2, add the words, provided, however, that this prohibition on separate sale or finance of the ADU shall not apply to a building that within 3 years prior to today, July 11th, 2016, was an existing condominium with no rental unit as defined in Section 37.2R of the Admin Code, and 2, has no evictions pursuant to Sections 37.9A8 through 37.9A14 of the Admin Code within 10 years prior to today, July 11th, and provided further that any such ADU may only be sold to a household whose total household income does not exceed 120% of AMI, and such requirement would be recorded as a notice of special restrictions or could be included as part of a regulatory agreement. So I think that, and I'll distribute those to you colleagues.
Thank you.
So I would, in addition to the earlier amendments, offer that amendment. Finally, as to unit size, and I do not have language, I am inclined, insofar as we have offered in the earlier amendments to remove the cap, to stick with the $350 for studios and $550 for one bedrooms. However, to accommodate what I think Supervisor Weiner brought up, which is if there is space left over, so you have a very large space and you can build 2 studios or 1 studio and a 1 bedroom, and there is space left over that is below the threshold but still within the building code minimums, that you could utilize that as an additional ADU, and I do not have language prepared to that effect. But we could work that in. And then finally, as to the bulletin number 4 issues, I would offer the following, which is, I think there is a vast difference between filling in under bay windows and filling in under decks and filling in light wells. I think if we were less broad and crafted this more narrowly, and we have attempted to do that, we could actually carve out pieces of bulletin number 4, and to that end, I am prepared to offer one more amendment. We can take these separately, which would define the existing envelope to include certain areas that are set forth in the zoning administrator's bulletin, specifically light wells that don't that are against a blank neighboring wall, i.e., so that somebody doesn't have to close up their windows, because usually light wells are for light. And I am going to distribute those. Lastly, there is the issue that I am sensitive to that Supervisor Wiener raised, which is that we not in any way amend the seismic, and the Plan Commission raised the same issue, that we not amend the seismic work that Supervisor Wiener pioneered, and I am prepared to remove the 311, 312 notice provisions as it relates to the seismic ADU legislation that Supervisor Wiener already passed.
Supervisor Peskin, a question for you. Not to be funny, but does size really matter? I heard some remarks, and I'm talking about unit sizes. I heard remarks, I think it was raised by Fernando Marti, a desire not to see very, very small units created. Just wanted to talk to you a little bit about that.
Yeah, I think as Supervisor Wiener said, to some extent this is a philosophical question, and sometimes more is not better. It is fundamentally a function of livability, and 350 square feet is...
Well, in this case, it's not more is not better, it's less is not better. Less in terms of square footage size for units.
So we're dealing with numbers of units versus size of units, and I think from my philosophical vantage point, this program will build more units. I would hope to build more quality units that are, on their face, livable, high-quality units, and I think space is a big part of that, which is why I would stick with the Mayor's Office of Housing, 350 for a studio and 550 for a one-bedroom. I think that's pretty modest and reasonable, but I do think that Supervisor Wiener has raised an interesting thing, which is if you utilize that space and there's still space left over that doesn't meet the minimums, I think there's various ways to deal with it. One is to say you can utilize the balance of a space, provided that it meets building code minimums, or alternatively that we could give the zoning administrator the authority to issue variances in certain cases. I do not have language prepared to that effect.
But would you be open to language to that effect? If
I'm certainly open to either one of those concepts, which is that if people built minimum size units in larger buildings, because remember this is really about larger buildings, that they would be, any leftover space could be utilized for an additional unit.
Yeah, because it seems to me that if I am comfortable living in a small unit, smaller than 350, then I should be the one to make that decision, right? Not an advocacy or a particular interest group. Supervisor Wiener, I see your name on the roster.
Thank you. Just a couple of things I want to point out. I appreciate Supervisor Peskin engaging in this amendment process. There's some of these amendments that I think are positive. Some are more challenging. One of the we want people to build these units, and building these units it's never easy. It can be costly. You have to go through a planning process. Although I know our city departments have tried work to get better and better in terms of the efficiencies and making it an easy process for people. It's always inherently there are going to be some challenges, and so there are already factors that can dissuade people from creating these units in terms of cost and process. And the more restrictions that we place on these units, the more we say, if you do this, there's going to be negative ramifications to your building, or this is going to be a different kind of housing. You're going to have restrictions that other housing doesn't have. It just dissuades people from building. I'm not saying that there shouldn't be any differences or restrictions, but at some point you end up just reducing the overall number of units because people don't want to deal with it, or it's not worth it to them anymore. In the end, this is housing. Housing is housing. And we want people to put these units in. If you say, no, this is a whole separate class and there's all these restrictions that other units don't have, why is it that an ADU would have restrictions that someone who's building in a non-ADU way, just building development, wouldn't have? Why are we treating one class of housing differently than others? If we want people to build these units, because we know that it is cheaper to build them than other units, they do tend to be more affordable, we should encourage people to build them, not disincentivize. So I look forward to the continued process. I do want to note one thing, that Ms. New asked that we withdraw the four-supervisor measure that Supervisor Farrell and myself and Supervisors, I believe, Tang and Breed put on the ballot. We're not prepared to do that at this point. It is, I think, my hope, and I know it's Supervisor Farrell's hope, that we can come to a resolution by the end of this month, which I think it's early August is the deadline to withdraw the four-supervisor measure. We're not prepared to do it now. This is not at a place where we would do that, but it's my hope and Supervisor Farrell's hope that we will get to that place. One thing I do want to correct, that there is an amendability provision in the ballot measure, the four-supervisor measure that we submitted. With a 2/3 vote, the board can amend it. So in terms of if there's anything that needs to be changed after it passes because of legal issues or whatever other issue, we can do that with 8 votes. So we're prepared to go to the ballot if we need to. It is our preference not to go to the ballot, and our preference to work this out in a reasonable way that works to actually expand housing in San Francisco and to start promoting housing rather than holding it back. I look forward to the process.
All right, thank you very much. All right, well, let's make some motions here. We've got a series of amendments. I've got 2 in front of me.
3
in front of me. All right, Supervisor Peskin, help me out with the
so
first
the
one.
first
I have the last 2.
amendment was the clerical amendments, including the Chapter 34 language, the amendments that lifted the cap, the amendment that created the minimum unit size. Those are all in the first 12 pages I handed out. The second amendment was the amendment with regard to subdivision, and the final amendment was the amendment with regard to the zoning administrator number 4 bulletin, clarifying what things could be filled in.
All right, thank you. So those 3 amendments, Mr. Clerk, we've read them into the record. Colleagues, can we take this without objection, or do we need a roll call vote? Mr. Weiner?
Oh, no, I'm happy to accept the amendments.
All right, thank you. Okay, so we'll take this motion made by Supervisor Peskin to accept the amendments without objection.
That is on the First Amendment.
Excuse me?
Is that on the First Amendment or all 3?
It's all for all 3?
Okay.
Do you need me to read them in? Supervisor Peskin already
And
read
I've got
them.
copies of them for you, Mr. Clerk. And then, colleagues, while there are, I think, a couple of issues still hanging out there, it would be my desire to work with my colleagues in the intervening week, and why don't we send this to the full board? We need not send it with recommendation, but why don't we spend the next week working to resolve those remaining matters? I pledge to deal with the issue over the seismic safety or seismic retrofit matter, and that I think is easily addressed as I spoke to earlier, and I'll prepare those amendments between now and next Tuesday and offer them at the full board.
All right, that sounds good. So we will send this legislation as amended to the full board without recommendation. And without objection, this motion passes.
That will be referred to the full board without recommendation as amended.
That's correct, as amended. All right. Mr. Clerk, are you ready?
Item number 7.
Item number 7.
Resolution imposing interim zoning controls for an 18-month period for all residential hotels requiring conditional use authorization for any applications for a permit to convert residential hotel units under Administrative Code Chapter 41 and in making environmental findings.
All right, Mr. Peskin is the maker of this sponsor of this legislation.
Thank you, Chair Cohen. I brought this legislation up over a month ago. Over a quarter of a century ago, there was a crisis having to do with the loss of SRO, single resident occupancy hotel rooms in San Francisco. In the late 1970s, the Board of Supervisors passed a moratorium on the conversion of SRO hotels to tourist serving and other uses. And in those days, the city did a count and found in the 1970s that we had some 33,000 SRO hotel units. Today, those have dwindled to 19,000. These units have traditionally housed our artists, people in our hospitality industry, neighborhood characters. They have been the housing of last resort, and they not only serve as transitional housing for those exiting homelessness or low-income families struggling to get by, but there are far more of the, as I said, the housing of last resort, and I think that frankly, we can do a lot better. And so as we have had the pleasure of working with planning staff and the community to draft revisions to the Hotel Conversion Ordinance, Chapter 41 of the Administrative Code, I wanted to offer this interim zoning control that would require conditional use. Believe it or not, conditional use is not required to convert in front of the Planning Commission, and so I would like to offer this 18-month conditional use interim zoning control as we work to bring Chapter 41 into the dawn of the 21st century. And if for those people who already have applications that are in the pipeline, this would not apply to them. It would only apply to anything going forward. So with that, subject to public comment, I seek your support to send this to the full board.
All right, thank you. I'd like to add my name as a co-sponsor to that. Thank you so much.
Thank you, Madam Chair.
My pleasure. All right, ladies and gentlemen, public comment. Anyone want to speak on item 7, please come up to the podium. Thank you and welcome.
Sue Hester, Urban Policy, think, not tank, no tank on there. I think this is way overdue. When I moved into the city, there was a lot of secondary units, SROs, group housing in the area, Upper Tenderloin, Lower Nob Hill, which is where I lived. There are a lot of residential hotels. They have been decimated. This legislation is needed. The planning department needs to really think through how it deals with the decimation, I think, of your district, District 3, and a lot of District 2 and some of District 2, because that is where we have a lot of secondary SROs and group housing. So I applaud this legislation, and hurrah, it's overdue. Let me be the first to congratulate us for doing it. Thank you.
Thank you, Ms. Hester.
Thank you. Any other speakers? All right, public comment is closed at this time. All right, Mr. Peskin, is there a motion?
I would like to make a motion to send this item to the full board with recommendation.
All right. This motion passes unanimously. Thank you.
That completes the agenda for today.
Thank you. This meeting adjourned. All right.